not rules, housekeeping ideas before we get started. Mr. Morris and I both have a noon conflict today. So we'll be breaking from 12 o'clock until approximately 1:15 or 1:30. I should have mentioned that to Dottie earlier, but I'm sure we'll see her again. But so just for your planning purposes, that's where we'll be. And then we will proceed then into phase one review of the issues. And I presume the parties will then be on standby while we go through those. And we'll just, obviously the panel's not discussed any of the issues so far, so I don't have any idea how long that will take, but we will certainly give it its due weight and time that's necessary to go through all those issues. Are there any other matters before we get started this morning? Mr. Williamson, I indicated to you up at the bench that I do have one question for Mr. Megaro, if you don't mind.
Not at all.
I meant to ask yesterday. Mr. Megaro, you stay right where you are, sir. Mr. Megaro, in terms of the Grace Humphrey matter, did you actually file a pleading, a notice of appearance in that case? Did you do the notice of appeal or anything like that? Or
Yes, sir. I did file a notice of appeal. I thought I mentioned that yesterday, but I don't think we introduced that. It's on our exhibit list, but I don't think we introduced
that's that was the reason I asked about the certificate of service, because I had not seen the notice of appeal or pleading with your name on it, but I did see the certificate of service, which implied to me that you had in fact made some appearance anyway in that case.
Yes, all I filed at that point was the notice of appeal.
Got it. All right. As a result of my questions, is any other, I don't have any questions, Mr. Morris, Mr. Bennett? All right, will be further evidence for the defense.
Yes, very briefly, Mr. DeVore, last night we went through and we do have excerpts from the previous deposition and some pointer, and have those copies for the panel and also for the state bar.
All right, Mr. Williamson, while you're looking at that, Mr. Halscott, were you able to find our flash drives for us for?
I am, sir. I'm just finishing copying over the last.
All right, very good.
Yes, and we have, I think both the paper list, exhibit list highlighted with the ones that we actually used in some fashion and would do.
All right, so we'll review those. That sounds like a good plan.
Okay. To have those. Oh, okay. First to State Bar Council, and may I approach the hand up?
Yes, of course.
We have
Testing.
oh, and I hope we have one for the court reporter. Okay.
Ms. Miotti, did you hear me say earlier that we were going to break at lunch at noon today? Mr. Morris and I both have conflicts or some other matter we have to deal with from 12 to 1. So I'm just giving you a heads up for lunch purposes. Thanks.
There's 3 and 3 excerpts.
All right, sir.
And on these excerpts, Amy, do you need copies too? Yeah, I believe they do.
Mr. Williamson, will these have file numbers, exhibit sticker numbers?
No, they don't. We could, what are we through 172?
I think it'd be better if we somehow mark them for purposes of the record as to what the
Sure.
exhibit number is for these.
The next two numbers, okay.
We do have a 171 earlier, didn't we produce that?
I think we had a 171 and 172. 172, we're submitting, that's the complaint in the civil case. 171 would be the supplemental report of Dr. Bellard.
We have that. I do not have a 172 that I recall.
Okay. It's digital. It'll be on our,
All right.
okay.
So
We're not
the-
really referring to it. It's really for the record.
So, Mr. Williamson, the deposition or excerpts from Gerald Brown, will that be exhibit 173?
Yes, let's do that. And, pointer would be 174. Oh, we have them listed?
They're listed as.
Oh, wait a minute. Okay, we can use them from our list. I'm sorry.
That's all right. Take your time.
Pointer 159
And 160.
and 163 for ransom.
Sorry, what was pointer? I was looking at something else. Pointer was what, Mr. Megaro?
159.
All right, thank you.
Those are the full ones. These are excerpts. They're like designations.
Why don't we do this? Why don't we mark the excerpts as with the letter A after one of them? So the excerpt will be one for pointer will be 159A. And the exhibit excerpt, the cuts from Geraldine Brown ransom will be 163A. And that way we'll be able to connect the two of them when we are looking at the
Sure.
record.
Thank you. And
163 to
I have 159A and 163A. Is that wrong?
that's correct, right? Yes. And Mr. House Scott, or getting,
3 or 4, I can give them the panel right now, and then the final one's finishing up.
okay. Have one for the state bar.
Yes, I have them to say part.
Okay. And the court reporter will need one.
Yes, sir.
Once I copy this over, you can use this one for somebody else. Won't take me but a second.
And Mr. Megaro is highlighting our copies of our exhibit list.
That's what I've got, Amy.
How many do we have? Okay. You got them ready? Okay.
More than half one.
If you'll indulge us just a moment, Mr. DeVore.
All right, take your time. All right. Does anybody else need a digital copy at this point? Go. One.
Yeah.
I've copied mine to the hard drive, so.
Chair DeVore, I'm finishing one more as well for the panel. So,
All right, I think we have it at this point. Richard, did you get a digital copy? All right. Okay. Take your time. Richard, at the break, I can put this on your computer if you, unless you want it now. You want to put it in? Put it in. We'll see. Okay, well, I can help you if you need to. All right, Mr. Williamson, I think we're ready to proceed. Will there be further evidence for the defense?
The evidence will be the exhibits that we have submitted in electronic form as reflected also on an exhibit list that we will shortly hand up.
All right, I'd forgotten he was doing that. Okay.
And those will be what we offer into evidence. I assume that will be sufficient, that we don't have to name every one of them. It's about 100.
Unless the state bar has an objection to any of those exhibits.
We would just like a copy.
Yeah,
of the
we'll get it circulated before you make a decision about that.
Here, while he's doing that, for the purposes of closing arguments and the panel's deliberations, we've created a 3-ring binder, which I've provided to Mr. Williamson today, which takes the amended complaint, each rule violation we have alleged, and behind it, we've organized it to where the specific pages of documents and evidence which we contend support those allegations. We've got that all combined for the panel's convenience. I've shown it to Mr. Williamson. I don't believe he has any objection to that. I could hand that up now for
Yes, sir.
purposes of time.
That seems to be a good use of time. Mr. Williams, any objections to that?
I haven't reviewed it, but I don't anticipate making any objection.
All right.
So that's fine.
That'd be fine, Mr. Murphy. If you want to distribute those, that would be
Yeah.
great.
Thank you.
Yes, of course. Yeah. Thank you.
Have that exhibit list. I'll hand a copy to Mr. Murphy here and to court reporter. Highlighted ones are the ones that we would.
Yep.
The highlighted ones are excluded or?
No, included.
Okay,
Included.
gotcha.
I just think it's it's just the summary of the ones they tend to introduce.
No objection to.
All right, then, for the record, let me just say these documents are now received into evidence on behalf of the defense. That's exhibits 1 through 4 inclusive, exhibit 12, exhibit 16, exhibit 28 through 30 inclusive, exhibit 32 through 42 inclusive, exhibits 57 through 60 inclusive, exhibits 74 through 83 inclusive. 73 is not highlighted on mine. Is it highlighted on yours?
It is on mine.
All right. Is that one that's intended to be included, Mr. Williamson? That is
I
the
assume so.
change.org account dashboard of Patrick Megaro.
Yes. Yes.
I got it. Exhibit 73. Exhibits 89 through 93 inclusive, exhibits 95 through 100 inclusive, exhibits 102, 103, exhibit 105, exhibits 119 through 124 inclusive, exhibit 127 through 129 inclusive, exhibits 132 and 133, exhibits 135 through 142 inclusive, exhibits 147 and 148, exhibit 150, exhibit 152 and 153, exhibit 156, exhibit 161, exhibit 167A, exhibit 167B, exhibits 170 through 172 inclusive, and most recently, that would be exhibits 159A and 163A. Did I do that correctly?
I believe so, yes.
All right, those will be admitted. Will there be further evidence for the defense?
No, sir, the defense rests.
All right, will there be further evidence from the state?
Just, we would at this time move to remit the rebuttal document that was previously distributed but had not been admitted. I believe it's 803, the letter from the District Attorney Luther Britt to the governor.
No objection to that.
Mr. Walthall, also, how about exhibit 801? Is that
I believe
already been admitted?
it has been. I moved at the wrong time, but thanks. There was no objection. It was admitted, I believe.
That's the one that you actually came up during the defense
Yes, sir.
examination.
Yes, sir.
801 and 803 are admitted on behalf of the state bar.
Thank you. No further rebuttal evidence from the state bar.
All right. And does the state bar wish to waive opening?
Yes, Mr. Chair, we do.
All right. Mr. Williamson, are you ready to proceed with closing?
Yes, sir. You ready, Mr. DeVore?
Yes, sir.
May I proceed? Mr. DeVore and the panel, we appreciate your close attention all through this week. I think that goes without saying. I hope I also have the self-awareness to take the hint from Mr. DeVore given yesterday evening that you have paid close attention, that this is a bench trial, and that you don't need a whole lot of argument to consider this case. Nevertheless, there are a few points I want to make with the hope that obviously whatever we say, you will consider with whatever time that you need. As trial lawyers, we are mindful that we hear in almost every trial in the jury instructions, when you're talking about the burden of proof, the admonition is, it is not the quantity of evidence, but its quality and persuasive force that the party with the burden of proof has to show. And again, in these cases, the burden of proof is clear, cogent, and convincing evidence. And you've got a lot of evidence. You have a quantity of evidence. And frankly, I would say it has seemed to me that both parties, both the State Bar and us, have presented a large amount of material in an efficient way, hopefully to give you a flavor as you come in knowing nothing about this, to understand what's going on in a very complex situation that went over a period of years. But with that in mind, I just want to mention a few things about some of the issues, but not all of them. Normally, in a case like this, you may only have a couple of issues or several. Here we've got, and I assume you're going by the State Bar statement of issues. We have no problem with that. It's basically the same that we submitted. It's all taken from the amended complaint, and there's a cornucopia of issues presented there. I want to address just a few of them. Just because I don't mention all of them doesn't mean we don't contest them, but it's just something that we wish for you to hear from us and to consider on certain of these. And I'm not going down in numbers on the issue sheet because some of them just, they lump together. They're kind of the same thing. They're variations on a theme. But there are certain broad issues I just want to say a few words about each. The first is the fee agreement that Mr. Megaro had with McCollum and Brown. And I'll be the first to admit, and it's why we bring it up the first right off the bat, is that it is worded in such a way that it can be considered to be improper. That is, to convey an irrevocable interest in the recovery. That's the wording. But beyond that, there is no showing of intent on behalf of Mr. Megaro that it be such that he have that interest in it. And I want to, in this matter, I just want to cite to you one piece of evidence that you didn't hear from the stand, but is in the ransom deposition at page 36. And this is from questioning of the State Bar Counsel. And the question is, did he, and that's Mr. Megaro, explain that your brothers and you, that you had the right to fire him if you wanted to? Answer, yes, he said that to us. I think that one statement, in addition to everything that Mr. Megaro has said about that, simply confirms that he did not have the intent to have any improper implication from the language of the fee agreement. The next one I'll say is there's an issue supposedly about sharing confidential client information with these two women, Pointer and Weeks. You have excerpts from their depositions. Actually, you have the entire deposition put in by the State Bar of Ms. Weeks. You have some excerpts from us of Pointer, but I don't know what that allegation entails. The only thing that I believe we heard as to sharing confidential information with him, and bearing in mind that these were people that were allegedly working on behalf of Brown and McCollum, was that Mr. Megaro sent at one of their requests a proposed fee agreement. How does that amount to sharing confidential information? I don't know. The next matter, and I have to say on this one, lawyers are prone to hyperbole, but I just don't get it. The Red Springs settlement, the allegation that Mr. Megaro did not do sufficient discovery about the insurance information, or that somehow the settlement with Red Springs was deficient. That seems to come from Mr. Tarleton. Well, how? Mr. Megaro got the insurance policies for the years prior. There seemed to be a gap in the 1 year we're really talking about, 1983, and the years afterward. So there appeared to be a real question as to whether there was any kind of insurance coverage for this matter. And then, as I understood it from cross-examination or the direct examination of Mr. Tarleton, that he had Ms. Wire review this situation. I know Ms. Wire to be very competent counsel, particularly in insurance coverage matters. And yet still they came to the conclusion that the settlement, the amount of the settlement for $500,000 each, Mr. Tarleton submitted that for approval. It was approved by the court. And beyond the insurance, we had this allegation you didn't look into the assets of Red Springs. There was some implication you didn't seek to discover through formal discovery the assets. Well, any trial lawyer knows you don't even have a right to discover the extent of someone's assets until you get a judgment establishing their liability, and then maybe you can do it by supplemental proceedings. But why does it matter? Mr. Tarleton did not even look at the publicly available information to see that the actual settlement is in excess of what this poor little town of Red Springs gets in ad valorem taxes in a year. So, and even beyond that, you heard Mr. Megaro testify as to all of the considerations, the nuances of the analysis of whether to take a settlement with Red Springs. And it's more than just where's the insurance and where's the money. You heard his analysis of liability, You heard his analysis of the strategic concerns that it would get the best lawyer for the defense out of the case, that it would get the only expert out of the case. It's the sort of thinking and analysis that a good lawyer goes through in deciding whether to pursue a settlement. Again, I don't get it. There is nothing to support that. The next, and this is one of the biggest things that the state bar seems to be relying upon, that is that it should have been obvious to Mr. Megaro that Brown and McCollum did not have the mental capacity to understand what was going on, did not have the mental capacity to handle their own affairs, and therefore he should not have entered into this representation agreement. Well, what about that? I mean, a couple of things. One is, we had a lot of expert testimony from Dr. Corbin, Ballard, Harbin, and understandably, there are differing opinions about that. Ballard, from his opinion, basically says that if you found Mr. McCollum incompetent, he was the most competent incompetent person that he had ever seen in his entire career. Now, how are you expected to say, well, anybody dealing with them should just know that? Well, if you say that, well, we know that even prior to Mr. Megaro getting into this case, they had hired another team of attorneys to handle the civil aspects of this matter, Mr. Hallett and a couple of local attorneys. How is that different? The difference cannot be the fact, if it's true, and we don't really know about that other agreement, that the other agreement did not include the industrial commission matter. That doesn't matter. What's important about this issue, if they're going to pursue it, is whether for any agreement that these men had the capacity to understand it. So, and I would also mention that it would also apply to Ken Rose's agreement, even to handle the petition for a pardon pro bono. That's still a decision that, you know, if you say they're incompetent, you shouldn't enter into that, because there was an obvious potential conflict of interest between the two, which would have needed to be explained to them, because the evidence of actual guilt, such as it was, the confessions and so forth, was stronger as to McCollum than as to Brown, and as we know. But finally, you know, as I was listening to the presentation of evidence, there was, by the State Bar, there was nothing said about the fact that the sister, Geraldine Brown Ransom, had a power of attorney. Okay. It is not just that these two men, you know, allegedly mentally disabled, signed it. The sister, Ms. Ransom, who, though it turned out, may not have been so scrupulous, but at the time, what appeared to be apparent to Mr. Megaro was, here's a sister of both of them, half sister of one, sister of the other, that you can certainly deal with someone with a power of attorney. If you can't, what does that mean? What does that mean in the law? If you suspect, and I suspect if you practice criminal law or personal injury, there are people and clients that come to you all the time that, you know, even if you may think, well, you know, they're not really quite all that I would expect in terms of their Mensa abilities or something. What do you have to do? Petition for a guardian of the estate before you actually represent that person? That cannot be the law. But that's the implication of this allegation. So again, I don't get it. The next issue I would bring your attention to, which the State Bar made a really big deal about, is the industrial commission fee. Well, and they noted that, well, yeah, it's pretty much a gimme if you have a pardon of innocence. Well, that's a condition precedent. And it's a big condition precedent. And the state was, they, through an MAR, their conviction had been set aside. But there was no foregone conclusion that the petition before Governor McCrory, who had never before issued any kind of pardon, would grant it. And indeed, as the evidence showed, nothing, it had sat there. And as the evidence also showed, these men were impatient with that. The question is, and it's speculative, would it have ever occurred but for the intervention of Mr. Megaro? What the State Bar would say, well, look at the situation there. Their convictions have been set aside. This is a foregone conclusion. I'm reminded of the Geico commercial. Why, even a caveman could have gotten that pardon. It's so easy. No. That's why we went through the whole presentation, that this is not something that a lawyer typically deals with. It's not something that Ken Rose, who had filed it, had ever dealt with. This is something that is a political decision. The strategy needs to be devised and needs to be executed in a political ball field, not in a courtroom that your ordinary lawyer is used to. Now, that leads also, is that an excessive fee? That's what they say. Well, if you look at it in isolation, sure. If there had already been a pardon, clearly that would be an excess fee. It'd be like the equivalent of saying, oh yeah, take a contingent fee on MedPay or something like that. But that's not the situation. The hard part is getting the condition precedent. And that's the purpose of our presentation, that all of the work that Mr. Megaro did, and indeed the uncertainty that he had after the meeting with the governor, where he was peppered with tough questions, did not come away with a good feeling. Again, broke the ice on the pardon front, got the pardon. Okay, that opened the field. But does that mean that it was an excessive fee? Because that not only was the gateway to the Industrial Commission recovery, it was the gateway for any realistic hope of getting a real recovery in the civil suit. And indeed, as soon as the pardon came down and the Industrial Commission matters granted, the civil case proceeds. And that's what's important about that. Without the intervention of Mr. Megaro to get the pardon, would there be any recovery on behalf of these two men? You say it's that easy? Well, you know, if you know how to play the guitar, it's easy to play that part of Louie Louie. But if you've never played the guitar and you don't know how to go about doing it, you'll never be able to do it, even if it's a simple tune. And Mr. Rose didn't know. Nothing had happened. Nothing was gonna happen. But it was Mr. Megaro to do that. And, you know, that's why it's not an excessive fee. That's why it's not any kind of unfair agreement with these two men. It's why it's not taking unfair advantage. Next thing is, this is wasn't made that big an issue about, but I just got to mention it. This business about, well, you didn't follow through on the trust fund for Leon Brown that was supposed to have been established after the competency hearing. Well, you know, what was contemplated from that was that Geraldine Brown was going to be the trustee. Well, it turned out that Geraldine, contrary to what had appeared before, was not a very trustworthy person. You know, she had a lawyer who was demanding of Mr. Megaro, send me the money so we can put it into an account that Geraldine controls. You know, at that point, she is the guardian. He has to somehow comply with that request, and he does it in the safest manner that he possibly could, which was to say, okay, but I'll trust you, the lawyer, will put it in your trust account, but we are not giving control to Geraldine Brown. So the failure to establish a trust, well, that was a reaction to the situation that had changed and had worsened, a situation where only later and without notice to Mr. Megaro was she kicked off from even the guardian of the estate for Leon Brown. The next matter, again, and these are all things I just don't understand. This business about improperly guaranteeing repayment of the loans, so these multi-funding loans, or even the Hamilton loan with the same language. He did not guarantee repayment. If you look at those documents, what he did was to acknowledge the interest of multi-funding in a recovery. He did not personally guarantee repayment. And, you know, these are forms and you may or may, there are reasons not to like even the concept of litigation finance loans, but you know, that doesn't make it unethical. And what he was doing, Mr. Megaro was not procuring those loans. It was clear from the evidence he was doing what the clients wanted. Again, clients who had a power of attorney. And if you look at, there's an ethics opinion, 2000 FEO 4, acknowledging a finance company's interest in a client's recovery. That's how this was structured. And if you say that's unethical, call Brian Oaken down and say, withdraw that opinion. because now we've determined there's something unethical about that. I've only got a couple more. Like I say, I'm not addressing everything that's been brought up in this kind of whack-a-mole position we're in. The next thing is getting Mr. Duffy to sign a false affidavit, what's suborning perjury or something, an affidavit that was never used, but that doesn't matter. What did he sign? He signed an affidavit after there had been representation to Mr. Megaro that Duffy was going to testify. He backs out. Mr. Megaro said, well, I don't know what to do. Here's an affidavit. The affidavit goes back and forth with his company, Multifunding. Well, what has changed on the affidavit that you saw? The interest rate, like a percentage point or something. How is that a false affidavit? I don't get it. The last one, again, turning from the first claim to the second, Grace Humphrey. I'm sure you can make your own assessment of credibility, but it certainly appears that Ms. Humphrey wins the weekly prize for least credible witness. And what's kind of funny to me is that the state bar would cross-examine Mr. Megaro and Mr. Housecott on all these issues brought up, but was there a word on cross about Ms. Humphrey? No. The testimony of Mr. Megaro stood unchallenged about that. And if you were to consider that he did something unethical in regard to that matter, basically you would be saying to the lawyers of this state that if you put in your contract that you, client, are responsible for this expense and have to pay for it, we have to have it to represent you, and you don't pay for it, what you're saying is you, lawyer, are guaranteeing that you will be responsible to pay it. That cannot be the state of the law here. So, and there are other issues raised. What I would say that never seen a case like this in the DHC with so many issues. But what's happened here is that you have a lawyer, Mr. Rose, and his buddy, Mr. Tarleton, both of whom admitted they don't care about the bar's confidentiality provisions, which are designed to protect lawyers at the investigative stage from unwarranted allegations. Mr. Rose says, I have a First Amendment right to talk to the press and say whatever I want to about Mr. Megaro. I don't care about the fact that the grievances I'm talking about are under investigation confidentially. Now, even worse, Mr. Tarleton says in a filing in court, talks about grievances, including this Grace Humphrey one that had nothing to do with that, with the case where he was the guardian ad litem. And I would repeat, he was guardian ad litem for a particular purpose, not as the state bar would have, well, he's the guardian. No, he's just appearing in the lawsuit. Why should anybody pay any attention to his impression about anything, especially when he can't even represent himself in the lawsuit? He signs this pleading with 6 lawyers. Well, he smirks, says, modus operandi. What does that mean? Yeah, I know that there's this other complaint, and that's just the way Mr. Megaro rolls. He's a walking exemplar of unethical behavior. That is exactly what the bar rules are designed to avoid. And exactly why we are happy to be here with you hearing the case, hearing the evidence, weighing it as it should. My client, for 4 years, has been smeared in the court of public opinion. And it continues. It continued at least up until Friday. There's an article in the Charlotte Observer and the Raleigh News and Observer. But here we are. I said in our opening, this is a case of overreach. I'm not blaming the bar. They're raising issues that other people apparently are bringing to their attention. I am blaming Mr. Rose. I'm blaming Mr. Tarleton. I'm blaming the press coverage, who is always seeking a villain. And they made my man a villain. I can't say it any better. And the patron saint of the lawyer representing vilified defendants, John Adams, representing the British soldiers in the Boston Massacre case. Facts are stubborn things, and whatever may be our wishes, our inclinations, or the dictates of our passion, they cannot alter the state of facts and evidence. We've been dealing in the public realm of the passions of the public, the passions of a couple of lawyers, Mr. Rose, Mr. Tarleton, with their own axes to grind, their own interest to the forward. But here we are dealing with facts and evidence. And as I indicated in my opening statement, we got the allegations, we've gotten here, we saw all the allegata, you have before you all the probata, the proof such as it is, that the evidence, and the reach just exceeds the grasp here. In closing, I would simply say, as you gave us the latitude, Mr. DeVore, to take the time we needed to present what we believed was necessary, we could have gone much longer. I hope we have presented it in such a fashion, and the state bar, both of us have presented in such a fashion that you have what you need to decide the case. We appreciate your time, understanding you've been here for an entire week away from your families and your work for the big $15 in box lunch a day. And I know that you will give it careful, dispassionate consideration in light of the law, the ethical rules, and the evidence that's been presented. Thank you.
Mr. Williamson, before you sit down, sir, what weight, if any, do you believe the panel should give to the decisions of Judge Boyle regarding the need for regarding and incompetency issues that were raised in the federal proceedings?
None. And the reason I say that, I know that was before you were chair, Mr. DeVore.
Yeah, I've
And
read.
Ms. Tomberlin, that was the collateral estoppel, non-mutual offensive use of collateral estoppel. The decision, won't go through all those arguments again. There's really no such thing. The standard was different. He never indicated that he's using the same standard. And the way I would characterize Judge Boyle's, the significance of that is it sets the stage. It is all part of what happened here, but that absolutely no weight should be given to his determination on those issues. The determination of those issues should be decided on the totality of the evidence you've heard here, which includes Dr. Corvin and Ballard and Harbin and the observations of everyone. Unfortunately, I guess we could have had Mr. McCollum here. I mean, he was available for Dr. Corvin's examination by Zoom. And I would also mention, of course, that, before he had his, at Mr. McCollum's insistence that his examination was recorded, and something on Zoom, if you want to record it, hit the button. Nobody, that's the thing. Nobody here has seen either Mr. McCollum or Mr. Brown say whether, well, how do they present? I'm sorry, I kind of went off on your question a bit, but the short answer is, again, none.
All right.
And I'm happy to answer. And I thought about saying, well, treat this like an appellate argument. You got any questions for me? I know you've heard a lot, but unless you have any, I'm happy to try answering any other questions. Otherwise, I'll just sit down.
Thank you, Mr. Williams. That'd be great. Thanks very much.
Thank you.
Mr. Walpole?
Mr. DeVore, my closing will be just a little bit longer than Mr. Williamson's. I wonder if we could take just a brief break so that we could set up some technology. And I don't want anyone to be uncomfortable as I go through, and I certainly don't want to have to take a break during my closing.
I think it's ready to wait. Bob, will 10 minutes be sufficient to do that?
Absolutely. And on that note, as we set things up, would it be acceptable to the panel if I were to give my closing from over here?
I don't have an objection to that. So.
Thank you very much.
So it's 10:03 now. Why don't we reconvene at 10:15?
Thank you.
All right, we're at ease.
Not only for people in this room, but for Henry and Leon, and for the attorneys and citizens of our state. You've seen a lot of documents, a lot of exhibits, heard a lot of testimony. I, for one, am tired. I'm sure you all are as well. But as the burden is the state bars for each of the rule violations listed in the amended complaint, I'm going to take a little bit longer than Mr. Williamson did. Hopefully not too long. I'll try to go as quickly as I can. But as I proceed through this, if you all have any questions, if I say something inartfully, which is likely, or if you want me to clarify something, please don't hesitate to stop me. I'm happy for this to be as interactive as you all would like for it to be. What I'd like to do is go through each of the rule violations listed in the amended complaint. And as I do, I'm going to show you selections of exhibits that have already been admitted into evidence. Starting with allegation G, and this is issue 7 on the issue list. Notice I'm going to try and largely go in chronological order rather than alphabetically. G concerns really the first instance of the defendant's misconduct as it relates to Henry and Leon. Specifically, it says, by entering into a representation agreement with his clients when he knew they did not have—
Mr. Walpole, I'm sorry to interrupt you just as you get started, but if you are showing things on the screen, we cannot see them.
Okay, thank you for noting that, Mr. Chair. We do want you to see them.
Give Mr. Bennett the credit for that.
Thank you, Mr. Bennett.
All right, so we have it now.
Thank you very much. By entering into a representation agreement with his clients when he knew that they did not have the capacity to understand the agreement, Defendant engaged in conduct involving dishonesty, fraud, deceit, or misrepresentation in violation of Rule 8.4C and engaged in conduct prejudicial to the administration of justice. Put simply, the defendant had Henry and Leon execute a retainer agreement with him when he knew they couldn't understand it. Notice how we've pled this from the beginning. We're not claiming defendant knew they met the legal definition for incompetency. We're claiming that he knew they couldn't understand the agreement. So really the question is, of course, what evidence is there of what the defendant knew prior to entering into that agreement with Henry and Leon? Well, the first bit of evidence we have in that regard comes from defendant's own response to the substantive grievance. As you'll see there in red, it is Exhibit 154 of your materials. He indicates in the highlighted portions of Exhibit 154 that I've listed there on the screen that he read some news accounts on the case, found the transcript of the motion for appropriate relief hearing online. He reviewed that and did some preliminary research before expressing interest in the case. Down below that, he says he spoke with the clients and their sister at length about the facts of the case, a plan of action for obtaining the relief they were seeking. He also explained that based upon his research, the clients needed to obtain a pardon of innocence by the governor as a prerequisite to their industrial commission claim because of their wrongful incarceration. He also knew that they needed to pursue a civil action under Section 1983 because of their wrongful convictions and incarceration. Let's unpack that a little bit. First, he read some news articles. Well, as we've seen in the materials, it's hard to find a news article that does not reference their mental retardation and intellectual disabilities. It's a big part of not only the legal case, which I'll get into, but also a big part of the public perception of this case. He also says he did research. Now, he says he researched enough to know that they should pursue a 1983 civil rights action and to discuss the case and the facts of it at length. Now, we respectfully submit that you cannot do a surface level amount of research on this case without seeing that Henry and Leon were mentally retarded. You heard testimony that that's not just a part of the case, that is the case. You heard testimony from Ken Rose, Vernetta Alston, and Raymond Tarleton that it wasn't just one issue, it was the issue. Why would anyone in their right mind sign a confession of a rape and murder of an 11-year-old if they didn't do it? Well, how do you overcome that hurdle? You show that they weren't in their right minds. That's the whole reason they were submitting this evidence of mental retardation. It wasn't for sympathy. It was to show that they couldn't understand a document, namely their confessions. So again, we submit that if you're researching this enough to discuss the facts at length, you certainly know that Henry and Leon are mentally retarded and couldn't understand a document. But he also says in his response that he read the transcript of the motion for appropriate relief. Well, here's that transcript. It's in evidence, Exhibit 607A. You heard from Vernetta Alston, who was there at this time. And unsurprisingly, because again, it was a huge part of their case, the fact that they couldn't understand their confessions came up in that transcript. This is page 85 of that transcript, actually page 91 of the PDF. This is Exhibit 607A. The question was asked, what did you look at regarding the believability of their confessions? And the answer, just one page over, they specifically mentioned that both of them were mentally retarded. Specifically mentioned that Leon has an IQ of 54. He's in the mentally retarded range. They mentioned the same thing with Henry. He was mentally retarded. He had an IQ of 56. He was in a special school for the emotionally disabled and mentally retarded. So it specifically came up in what the defendant reviewed before he ever had them sign a retainer agreement with him. It's there. He said he read it. We know he did. Now, defendant would have you believe that he spent hours with these clients discussing the history of their case and that these clients were like every other client he had. That is simply inconsistent with the evidence. You heard testimony from 3 attorneys in good standing in North Carolina who have no financial interest in the outcome of this DHC proceeding whatsoever, who stated unequivocally that as soon as they met Henry, they knew he had mental deficiencies that kept him from understanding things like other adults do. It's obvious, it's discernible. You also heard testimony from Dr. George Corvin, an expert forensic psychiatrist, who said that even a layperson would notice Henry and Leon's deficiencies. Excuse me, just Henry. He was only referencing Henry. Nonetheless, notwithstanding all of that research he did, notwithstanding the news articles he read, notwithstanding spending hours with them, notwithstanding reading this motion for appropriate relief transcript, he still entered into a contract with them, it's Exhibit 105, and had them sign it without a guardian and without their counsel of record present or even knowing about it. Now, defendant contends that Geraldine showed him but did not give him powers of attorney for both brothers. That document is not in evidence, if it exists. We contend it doesn't. Again, it hasn't been turned over. Thousands of documents have been submitted. In fact, the defendant wired money to Henry and Leon, gave them cash, over $1,000 to mail him documents. He said he had numerous bankers' boxes of documents in this matter. Guess what's not there? Those powers of attorney. And in the selections of the Geraldine Ransom deposition transcript, she doesn't mention having powers of attorney. There's nothing in evidence other than the defendant's statement that those powers of attorney even exist. Now, defendant claims that Henry and Leon understood this contract, Exhibit 105. But defendant's own expert cites a conclusion from Dr. Richard Rumor, who evaluated Henry and concluded that the confession he signed was well above his level of literacy. One of defendant's experts in this matter testified to this panel in this case, the same thing, that it's his opinion that Henry's confession was well above his level of literacy. Well, let's look at that confession. Just a bit of it, not the whole thing. I'm just going to show you a couple portions of it. This is Exhibit 601. It's in your materials. You can read all of it. Just want to read just a couple portions. On Saturday, September 24th, I was standing at the intersection of Richardson Street and Old Maxton Road. This was about 9:30 p.m. Sabrina Buey and Daryl Suber came out of Suber's house and walked toward me. Lewis Moore and Chris, I don't know Chris's last name, they walked up to the stop sign where we were. Just a few minutes later, my brother, Leon Brown, came up to the stop sign. All six of us walked down the road to the little red house. Later on in the confession, he says, we walked across the ditch and Daryl and Chris pick up this board about 2 or 3 feet wide and about 6 feet long and carried to the woods at the edge of the field. All 5 of us went into the woods at the edge of the field. Me, Daryl, and Sabrina still had our beer cans. Let's compare that to the contract the defendant had Mr. McCollum and Mr. Brown sign without a guardian or attorney present. I'm just going to read you just 2 sentences of this agreement. It's several pages long. It's in your materials, Exhibit 105. I just want to read 2 sentences just for comparison's sake. The first one there has an arrow, as you see on the screen. HM, which stands for Hall-Scott Megaro, will be compensated by a contingency fee interest as follows. A, before the filing of an answer or the demand for appointment of arbitrators, or if no answer is filed or no demand for appointment of arbitrators is made, the expiration of the time period provided for such action, 1, 33% of any recovery up to $1 million, plus 2, 30% of any portion of the recovery between $1 million and $2 million, plus 3, 27% of any portion of the recovery exceeding $2 million. That's sentence 1 that I want to read you. Sentence 2. When you sign this agreement, you are conveying to us an irrevocable interest as outlined herein in the net proceeds arising from prosecution of the matter, whether obtained by settlement or by judgment or otherwise, and whether denominated actual damages, costs, attorney's fees, punitive damages, or other recovery, and in whatever form they may take. The notion that Henry and Leon could understand that, but not understand their confessions that they signed, particularly after 3 decades in prison made their mental state worse, which I believe everyone agrees with, the experts and defendant included, simply does not make any sense. It's not consistent with the evidence. It's no wonder then that Judge Boyle, in his order, Exhibit 166, found that based on the foregoing, Henry lacked capacity to enter into a representation agreement with counsel in March of 2015. I'll note here, as Mr. Williamson said, there is no indication in this order as to what standard of proof Judge Boyle used when entering this, but he does specifically cite North Carolina General Statute 35A, and the standard of proof in that statute to find someone incompetent is by clear, cogent, and convincing evidence, the same standard of proof for this tribunal. Judge Boyle also said, in other words, counsel, that is the defendant, Mr. Megaro, was plainly on notice that his potential clients had intellectual disabilities and that their abilities to proceed without a guardian were at issue. Nonetheless, counsel, that is the defendant, entered into a representation agreement and has, to the court's knowledge, never sought to have the agreement ratified by any duly appointed guardian for either plaintiff. Accordingly, the court finds, based on McCollum's incompetence, the representation agreement between counsel and McCollum is invalid. That, of course, is consistent with the evidence we just looked at. We know what the defendant looked at before he entered into the agreement with them. It specifically mentioned that they could not understand a document. And so whatever you want to call it, whether it's incompetency, mental retardation, intellectual disabilities, what we're talking about is their ability to understand a document, either the confession or the retainer agreement. They can't understand the confession. They certainly can't understand the retainer agreement. I'll note here too, there's only one expert you've heard from who has evaluated if Henry could understand the retainer agreement, and that's Dr. Corbin. You saw from Dr. Harbin and Dr. Ballard, they did not even analyze that. They were analyzing if he could accept or reject the settlement agreement and handle his affairs. They did not analyze if he was competent to enter into the retainer agreement. Only Dr. Corbin did that, and he specifically said that they could not. There's clear and convincing evidence of the allegations in G. A and B concern the language in the retainer agreement, some of which we just read, and these correspond, I believe, to issues 1 and 2 on your issues list. By claiming an irrevocable interest in McCollum and Brown's potential financial payments from the state, the defendant charged an improper fee and engaged in dishonest conduct. He also attempted to limit his client's absolute right to discharge him in violation of Rule 1.16A3 and made misstatements about his services. This is clear and convincing evidence in black and white in the defendant's contract. Again, this is Exhibit 105, pages 3 and 4, where he says, "You are conveying to us an irrevocable interest as outlined herein in the net proceeds arising from prosecution of this matter." The defendant originally claimed that this came from a Texas form, but Texas does not allow this either. That simply doesn't make sense. And even if it did, he's using it in North Carolina. It's not permitted here. He also says later in that same contract that he had Henry and Leon execute without the presence of a guardian or counsel. "If you elect to terminate this agreement, it will not terminate our contingency interest in the outcome of this matter. Under no circumstances are we required to relinquish any part of the contingency fee provided herein in order to make the accommodation for new counsel." Telling them that, hey, you're allowed to fire me if you don't like my tie doesn't change what's listed here. He's not saying here you can't terminate me. He's saying if you do, I still get your money. C concerns these consultant advisors, Deborah Pointer and Kim Weeks. As you've seen over the past few days, the first folks to manipulate Henry and Leon when they got out of prison and get them to sign a predatory contract with them were Deborah Pointer and Kim Weeks. These are not attorneys, not anyone's paralegal. They're not defendant's employees, and from the materials that have been submitted, they were engaged in the unauthorized practice of law. Nonetheless, the defendant routinely shared confidential client information with them, and make no mistake, the information the defendant shared was confidential. The third comment to this rule notes that the confidentiality rule applies not only to matters communicated in confidence by the client, but also to information acquired during the representation, whatever its source. Yet, as we've seen, the defendant sent them a copy of his retainer agreement. He corresponded with them about the loans given to them based on information he had obtained during the representation. He says to Deborah Pointer, everything was signed and sent over. I think the checks will be sent out tomorrow. That is information to which they have no right, and in fact, ended up harming Henry and Leon because these two women were able to get a portion of that money, which defendant knew about. He initialed pages of that loan contract that indicates that Deborah Pointer and Kim Weeks were to get $5,000 from each brother. We also saw that defendant's own personal notes detail a number of phone calls with Pointer and Weeks wherein confidential client details were discussed. There, March 2nd, 2015, defendant says that he set up a conference call with Deb, which is Deborah Pointer and Kim Weeks, to discuss immediate funding on the case, how the lenders need the notice of claim and proof of exoneration. All that's confidential client information that cannot be shared. The second note there, March 16, 2015, they talk about collecting medical records, Robeson County court files, looking into other court records, talking about getting a rally together for the brothers. Deborah Pointer and Kim Weeks have no right to that information. The defendant has no right to share it with them. Notice also, just as an ancillary matter here, the highlighted portion there, the defendant was so worried about other lawyers trying to, in his words, poach the case that he paid for a plane ticket for Charles Gallman to fly down from New York to North Carolina to see that that didn't happen. Does that sound like an attorney who believes his clients can make their own decisions and can decide whether or not to enter into an agreement? Or does it sound like an attorney who knows his clients can be convinced to sign anything and he's worried about that happening? It's clearly the latter. I concerns the excessive fee with the industrial commission matter. I want to read this one to you, it's short. By charging and collecting 1/3 of McCollum and Brown's industrial commission award when his role in that process was minimal and pro forma, defendant charged and collected an excessive fee in violation of Rule 1.5a. As we've seen when Henry and Leon were released, there were 3 legal matters that they were pursuing through counsel. One was the pardons. The second was the industrial commission award. The third was the civil suit against the parties responsible for their wrongful incarceration. Notice how this is pled. We're not referencing the pardons, not referencing the civil suit. We're only referencing the defendant's actions before the industrial commission. Now, those 3 matters, the pardons, industrial commission award, the civil suit, are 3 separate actions. They had different filings, different decision makers, different rules, as the defendant said himself, different discovery rules, different branches of government, different goals, different amounts of work, different levels of compensation, different levels of risk. These were separate matters and their fees should be analyzed separately. That's how we've pled this. We've made no secret of it since the very beginning. This is how it's listed in the amended complaint. This is how it's listed in our issues list. This is how it's listed in the defendant's issues list. Was the fee for the industrial commission matter excessive? It clearly was. Having said that, even if we consider the pardons and the industrial commission matter linked, the $500,000 fee is still clearly excessive. We know from the documents as Exhibit 102 that before defendant was ever involved with Henry and Leon at all necessary documents for the pardons had been submitted. Not some, all of them. Now, defendant claims he worked several hours to get these pardons, but you've heard credible testimony from Ken Rose, Vernetta Alston, and Raymond Tarleton completely contradicting that. Not to mention this documentary evidence that says that everything that needed to be submitted had been submitted. You've heard testimony explaining that this was an extraordinary pardon because of the brother's mental condition, the DNA evidence that they found later on, and not the least of which, the DA, the DA's office that had been trying to execute these brothers, that had been prosecuting this case for years, sent a letter to the governor saying, would you please pardon them? Contrast that with the videos the defendant showed of another pardon he worked on in a different state, where the state actors were actively against that. They were actively working. We saw in one of those videos, I don't remember which one it was, that they were against issuing those pardons. Well, here, everybody on either side of the courtroom was cheering for these pardons. It was no ordinary pardon petition. Moreover, uncertainty as to whether or not the pardons would be granted doesn't mean that the legal work that went into that was either necessary or complex. We saw evidence that there was already media attention before the defendant got involved. There was already pressure from multiple individuals meeting with the governor, asking him to grant these pardons. As you heard from Ken Rose, that he joined with the NAACP and meeting with Governor McCrory to ask him to issue these pardons. The defendant wasn't even there. But again, that's not the issue. As we've pled it, was his fee before the industrial commission matter excessive? It clearly was. The statute says if the Industrial Commission finds from the evidence that the claimant received a pardon of innocence for a reason that the crime was not committed at all, the Industrial Commission shall award to the claimant an amount equal to $50,000 per year, capped at $750,000. Once the pardons were issued, the defendant filed a petition before the Industrial Commission, as you saw, using almost exclusively documents he had received from Ken Rose and Bonetta Alston, and he appeared at that hearing and said just over 300 words. And for that, he charged almost $500,000. Not terribly good at arithmetic, but I believe that comes to approximately $1,000, $1,600 per word. It's a clearly excessive fee. You heard this proceeding described as formulaic, uncontested, checking boxes, simple, automatic, mandated by statute. Defendant himself admits he could not have received less at the Industrial Commission. This is a selection from his deposition transcript where I asked, once it's granted by statute, that is the pardons, they're entitled to the Industrial Commission award. Is that correct? He said, yes. I said, was it mandated by statute that they receive that amount? Yes, it was set by statute. After receiving the pardons, could they have received less than the $750,000? He said, I don't think so. And as you've seen, the breakdown the defendant provided of the $1.5 million that his clients received from the Industrial Commission, the defendant took almost $500,000, $250,000 from each brother. This misconduct is similar to that contemplated by at the MedPay ethics opinion that I believe Mr. Williamson mentioned in his closing. It says there that a lawyer may not charge a contingency fee to collect MedPay because with most MedPay claims, there is no risk that the insurance company will refuse payment, and there is no dispute as to the amount due the claimant. Therefore, such contingent fees are unreasonable in violation of what was then Rule 2.6a because the element of risk, which is necessary to justify the typically elevated contingent fee, is not present. Let's unpack that. The fee described here in this opinion is unreasonable and excessive because one, there's no risk that they wouldn't be paid, and two, there's no dispute as to the amount. That's exactly what the Industrial Commission matter was. No dispute as to what amount they were to receive. It was set by statute. There was no doubt that they had to receive it. Again, that was set by statute. The work the defendant did in the Industrial Commission matter does not justify a $500,000 fee. E and F concern the defendant's withholding of money from the Industrial Commission award to pay costs that he was supposed to pay, that he was contractually obligated to pay. These relate to issues 5 and 6 of our issues list. Again, looking at the retainer agreement, the defendant had Henry and Leon sign without the presence of a guardian or their counsel of record at the time. The defendant says to them that Hall-Scott Megaro agrees to advance all such costs and expenses incurred in connection with the matter, including specifically expert witness fees.
Mr. Walthall, let me interrupt you about this point.
Mhm.
What is your thought about whether or not our rules provide that an attorney, in terms of advancing expenses, can make them contingent, I think, on the outcome of the case? But is there some concern that when an attorney has advanced all the cost in a case like this, that there is a conflict of interest because they then gain an interest in the case?
I don't, if I understand your question, I don't believe the answer to your question is yes, because I believe attorneys are allowed to advance costs of litigation. We, of course, have some advances here that we'll get into a bit that were not for the costs of litigation. But an attorney advancing costs of litigation is permissible. And that's what they were contractually obligated to do here. That's part of what justified the contingency fee, right? Like we just read in that ethics opinion, is that, hey, we're advancing costs, but then we get, a bigger piece of the pie than we would otherwise get at the end.
So if if there had been no recovery under this fee contract, then would those expenses just remain then the cost of Mr. Megaro and his firm?
That's my reading of the contract, and that's the risk that justifies the contingency fee.
All right, sir, go
Yes,
ahead.
sir. Thank you. So the firm agrees to advance all these costs. And then when the Industrial Commission award is given to the brothers, the defendant withholds $10,000 from each one to pay for, among other things, expert witnesses. He took $10,000 from Henry, took $10,000 from Leon. And we know the defendant did in fact spend this money on the costs of the civil suit. It says at his deposition, use that money from the Industrial Commission, both for the costs that you'd already incurred, the Industrial Commission, and the cost of the civil litigation. He says yes. And then asks, okay, so Dr. Harbin was paid $4,000 out of the money that you withheld from the Industrial Commission. He says that's correct. Now, defendant claims Henry and Leon understood this expenditure. They wanted to give him this $10,000. Well, when defendant took that $20,000 from Henry and Leon, he had already pled this in Exhibit 116. Both brothers need assistance with budgeting their monthly allowances because they're unable to understand the concept of paying utility bills and making purchases. What is this if not making a purchase? He also said one thing is clear, neither Leon Brown nor Henry Lee McCollum have a concept of budgeting or spending limits, nor do they have any experience in managing money, let alone large sums of money. I don't know about you all, but $20,000 is to me a very large sum of money. He also says that Henry and Leon need protection from fraudsters and frivolous spending. It's no wonder then that Henry didn't understand that taking of his money. She testified to and made its way into Judge Boyle's order. Henry McCollum further explained that he received half or less than half of his award from the North Carolina Industrial Commission for his pardon of innocence because, as his attorneys explained, they had to take out money for his future civil case and expenses. There's clear and convincing evidence based on not just Judge Boyle's order, but defendant's own statements and pleadings of the violations listed in E and F. P concerns these advances to Henry and Leon for things other than litigation expenses. As we've seen from Exhibit 121, the defendant repaid himself for advances he had made to Henry and Leon out of that $1.5 million. Almost $12,000 to Henry and over $14,000 for Leon. And again, we need to look no further than defendant's own documents to show what these advances were for. Tire service, resort fees, Majestic leasing bus. Those are not litigation expenses. They're giving money to their clients to go on vacation, lease a bus. It's obviously not litigation. And why does this matter, right? Why would that matter? Well, you heard testimony explaining that attorneys can't just give spending money to clients because one, creates a conflict by making you their lender. And two, it can be very manipulative. It buys their loyalty. And the risk of that is particularly acute in a case like this, where we have clients who have diminished capacity, who cannot understand paying bills, have no concept of money, as the defendant has pled. It's clear and convincing evidence of these violations. J concerns the defendant's misrepresentations to the clerk of Superior Court, indicating that he would set up a trust for Leon's funds. Understand, and this relates to issue 10 in your issues list. For this, we really need to look no further than the defendant's own statements. At that hearing for the clerk, this is Exhibit 118, page 19, the defendant said about this trust, it's drafted and it's ready to go. As soon as it's funded, it'll come into being. He further said, there's going to be multiple levels of oversight. The trustee is watching the guardian is watching the trustee, and the court is watching everybody. In the actual pleading the defendant filed, this is Exhibit 116, he said, in order to protect both Leon Brown and Henry Lee McCollum's property, undersigned counsel has consulted with an independent financial advisor and has drafted a living trust domiciled within the state of Florida for the benefit of Leon Brown. The purpose of the living trust is to generate income for the benefit of Leon, to cover his basic living expenses and to provide for his medical care, as well as to provide income so that he may enjoy life as any normal person. The secondary purpose of the trust is to protect both Leon Brown and Henry Lee McCollum's assets from fraudsters and frivolous spending. So did the trust come into being as soon as defendant received the Industrial Commission Award? Nope. Again, relying only on defendant's own words in this letter that he sent to Dwayne Gilliam, as Exhibit 136, the defendant indicates, and he received those funds on October 21st, 2015. He held them in his trust account pending funding of that living revocable trust, which he admits he was required to do by the court. He held that money for 60 days and never put it in a trust as he claimed he would. H concerns the defendant's misrepresentations to the court in the civil suit. By having McCollum sign off on a settlement agreement and representing to the court that McCollum had consented to the settlement, when the defendant knew Henry did not have the capacity to understand the agreement, the defendant made a false statement to a tribunal, engaged in conduct involving dishonesty, and that was prejudicial to the administration of justice. Here is that consent motion where the defendant made these representations, at least in his pleading. Notice that the date is April 11th, 2017, when he made these representations. So what representations to the court did the defendant make in claiming that Henry was able to consent to the settlement agreement? That's the question, right? What representations did he make in saying that Henry could accept this settlement? Well, looking first at this pleading, it's Exhibit 150, he said that Dr. Harbin has determined that Henry Lee McCollum is legally competent to enter into the settlement agreement and to manage his financial affairs. Defendant admitted during his testimony that he held out to the court that Henry was competent to enter into the settlement agreement and that he believed Henry could understand it and could manage his financial affairs. And that is consistent with the transcript. Defendant did hold out to the court, saying, I don't believe that Mr. McCollum needs a general guardian because he's been living on his own and managing his own affairs for close to 3 years now. He also said, I always believed that Mr. McCollum was legally competent under North Carolina law to manage his own affairs. He also said in a pleading, this is Exhibit 709, that there is no credible evidence that Henry Lee McCollum is mentally retarded. Now, to show that these statements made in the context of both trying to protect his retainer agreement and trying to get the court to understand that Henry could in fact consent to this agreement, to show that these were clearly dishonest, we could examine the numerous expert opinions, concluding that Henry is mentally retarded and unable to understand written documents. We could look at the numerous courts that have noted the same or similar. But I think the best evidence of defendant's dishonesty in this regard would be defendant's own prior statements. So let's look at defendant's own prior statements and see if we can find something contrary to this statement here in Exhibit 709 saying there is no credible evidence that Henry Lee McCollum is mentally retarded. First would be this mediation presentation that we've looked at, that the defendant drafted and presented. And look, the docket number is the same. It's the same case in which he filed this, the same case. He presents in this PowerPoint multiple slides entitled Evidence of Mental Retardation. Defendant notes on these, and by the way, what I've done here is 4 of his slides into one, just for the sake of time, but just so you know, these are more than just one slide here. Defendant notes that courts have called Henry mentally retarded, specifically cites the North Carolina Supreme Court from 1993, cites the Supreme Court of the United States from 1994. The next set of slides, the defendant claims that Henry meets the legal standard for mental retardation, notes that there is significantly sub-average intellectual functioning and significant limitations in adaptive functioning in Henry. He cites 4 different experts who evaluated Henry and concluded he was mentally deficient. The defendant presented page after page after page after page after page of evidence of Henry's mental retardation, over 30 PowerPoint slides with detailed evidence. And why would he do that? Was it to elicit sympathy? No, because that was the case. The biggest hurdle that Henry and Leon had to overcome is that they signed these confessions. How do you overcome that? By showing their mental retardation, by showing that they couldn't understand the document. In addition to that mediation presentation, the defendant had also pled this, Exhibit 116. We've seen this before, where the defendant claims that both brothers need assistance budgeting their monthly allowance. They're unable to understand the concept of paying utility bills or making purchases. Now, defendant filed this pleading August 15th, 2 years prior to the defendant's claim to the court that Henry was competent to manage his financial affairs and enter into the settlement. So 2 years prior to that, this is what the defendant pled. Now, shortly after the defendant made these claims that you see here in Exhibit 116 in a filed signed pleading, Henry received $360,000 from the Industrial Commission. He received that money on October 21st, 2015. Just over 6 months later, the defendant signs various pages of a loan contract to Henry from multifunding for $50,000 at 18% interest compounded every 6 months. That was with the defendant's knowledge and help. And that's just one of them. We've seen evidence, and the defendant saw it as it was happening. Henry blew through over $440,000 in a year and a half. So just to recap, the defendant has claimed Henry is mentally retarded. Defendant has shown that Henry meets the legal definition of mental retardation. Defendant has shown that multiple courts and experts have concluded that Henry is mentally retarded, all for the purpose of showing that he couldn't understand a document. Defendant has pled that Henry doesn't understand paying his bills, doesn't understand making purchases. Henry has no concept of budgeting or spending limits, that he can't manage his money, that Henry needs protection from fraudsters and frivolous spending. And defendant has seen Henry blow through over $440,000 in a year and a half, and yet he still claims this to the court. Henry can manage his financial affairs. He's fine. Doesn't need a guardian. He also claims there's no evidence of mental retardation. That's clear and convincing evidence of all the violations listed in H. K, which I believe is issue 11, concerns other misrepresentations made to the civil court. Specifically concerns the defendant's misrepresentations to Judge Boyle when he claimed work he had already been quite handsomely paid for as justification for his fee in the civil suit. Local Rule 17.1 required the defendant to provide the court a summary of services rendered by counsel so the court could determine the fairness and reasonableness of the settlement and the attorney's fees, as you heard testimony from Mr. Tarleton. Well, in that consent motion, again, this is Exhibit 150, the defendant specifically holds out to the court in paragraph 6 that he provided the following services in this action. Counsel represented both plaintiffs in their successful petitions to the governor of North Carolina for pardons of innocence, which included several meetings with Governor Pat McCrory and/or his office, submission of documents and information to the governor's office, and several meetings with plaintiffs. Counsel represented both plaintiffs in their successful petitions for statutory compensation for wrongful imprisonment pursuant to General Statute 14882 in the North Carolina Industrial Commission, which included preparation of the petition, appearance in the commission, and presentation of evidence at the hearing. Now, just as first matter, defendant leaves out that he didn't file the petition pardons and that the Industrial Commission matter was unopposed. But setting aside, the defendant left out some key facts there in his representations to the court. The defendant is claiming here that this work is part of the justification for his fees in this case, as is apparent just a few pages later in that same pleading, where he holds out that his fee is reasonable. Part of the justification for that are the services he listed above. He, of course, does not inform the court in this pleading that he'd already been paid almost $250,000 from Henry and from Leon for that work. Now, the defendant has claimed, well, look, it was all one case. It was all one matter. It's all lumped in together. But this, again, is directly contradicted by the defendant's own statements. When the defendant refused to tell Judge Boyle what his fee for the Industrial Commission matter was, he said, that's something that's confidential to both clients. That's something that is outside of this litigation. He also said, that's separate litigation and a separate state court and has nothing to do with these proceedings here today. D concerns the failure to ascertain the ability of the town of Red Springs to pay in excess of their insurance policies and fail to determine the insurance policy limits. Defendant makes much of the alleged steps he took to discern the assets and insurance of the town, but again, his own statements suggest otherwise. We asked the defendant at his deposition, did you serve the town of Red Springs with discovery requests to determine their assets and liabilities? No. He says it was premature. Well, surely, if you're entering into a settlement with them, not premature to that. We also saw the email between Raymond Tarleton and Patrick Megaro, where Raymond asks, what are the insurance policy limits? What are the limits? His response, nobody was sure, including the insurers themselves. And again, that's not his entire email. It's in your materials, Exhibit 153. I encourage you to read it. We've pled that he failed to determine the limits, and that's what's here in Exhibit 153. The only allegations we have in D are lack of competence or diligence. Diligence isn't just a prohibition on taking steps that might harm your client. Diligence means taking affirmative, proactive steps to get to the bottom of things to help your client. Defendant did not do that here. And why would that matter? Well, as we saw in Exhibit 156, similar cases and what they settled for. Dwayne Dale spent 18 years in prison wrongfully. He received 7.5 million. Greg Taylor spent 17 years in prison where he was exonerated and he received 4.6 million. Floyd Brown spent 14 years in a psychiatric hospital based on fabricated confession after the SBI interrogated him, who had a low IQ and a mental capacity of a child, and they ignored clues of an alternative suspect. Does that sound familiar? It's very similar to the case here, except of course he spent less than half the time that Henry and Leon did, and he received 9.3 million. Now, the document here, Exhibit 156, which is in evidence, does not detail the other circumstances of these settlements, but it is indicative that a $500,000 settlement with the town of Red Springs before you truly gotten to the bottom of their assets is a lack of diligence. L and Q concern these loans, which we've heard so much about. Let me read them. By signing various attorney acknowledgments of explanation and of terms to plaintiff of irrevocable lien and assignment to Multifunding, Inc., claiming to Multifunding that he had explained the terms of loan agreements to McCollum and Brown when they were not competent to understand those terms or enter into those agreements, defendant made material misrepresentations to Multifunding and engaged in dishonest conduct. He also, by his participation therein, entered into business transactions with his clients. Here's what we know from the documents. The defendant signed multiple pages that read this. I hereby consent and agree to fully execute this document to pay Multifunding all funds due them at the close of this case. Before final distribution to the plaintiff, attorney acknowledges that I have reviewed the contract and explained to plaintiff the terms contained therein, including but not limited to the annualized rate of return set forth in the disclosure statement. So we know the defendant agrees to pay Multifunding out of his client's proceeds and states that he's explained the contract to his clients. It's right there, black and white. That's defendant's signature. We know, contrary to the defendant's claims, that the pages he signed were in fact pages of the loan document. This is, again, black and white between Multifunding and Mr. Megaro, where they say, hey, here's the signed contract for Henry. When you get a chance, please sign and return pages 10 and 12. We know from multi-funding that without the defendant's involvement, these loans would never have been issued. Multi-funding says, yes, without his signature on this page, we would not have proceeded. I asked, would this loan have been funded without Patrick Megaro's signature here on page 10? He says, no, it would not have. Multi-funding also confirms that the defendant agreed to repay these loans prior to paying his client. Is it your position that by signing this, Mr. Megaro is agreeing to repay the loan prior to paying the plaintiff? Yes. Defendant himself admits in a pleading that he assisted Henry and Leon in getting these loans. He says in the course of representation of the civil claims, undersigned counsel assisted both Leon Brown and Henry Lee McCollum with obtaining a cash advance loan of $100,000 from a legal loan company. Notably, he leaves out in the pleading that it was an 18 or 19% interest rate compounded every 6 months, but he nonetheless admits that he assisted them in getting these loans. We also know that upon request from multi-funding to approve these disbursements, the defendant initialed them, including disbursements to Kim Weeks and Deborah Pointer. Finally, we know that the defendant had the power and ability and authority to stop these loans. Multi-funding reached out and said, hey, Leon wants an additional $25,000 loan. Ms. Megaro responded, please hold off on that right now. There's a situation developing. I will be in touch shortly to explain, but please do not fund that until we speak. Defendant characterized this as an email that said, proceed at your own peril on direct exam. That's not what this says. It says, please do not fund that. And what did multi-funding do? They complied. They did not fund that loan. So in sum, the defendant signed contracts agreeing to pay multi-funding. We have them in our evidence. Defendant's signature was required. That's in evidence as well. Defendant assisted Henry and Leon in getting loans. That's in defendant's own statements. Defendant approved disbursements of the loans as indicated by his signature or his initials on those pages. And the defendant had power to stop the loans. Thus, there's clear and convincing evidence of the violations in L and Q. R concerns the affidavit that was tangential to those loans. This is issue 18. Here is that affidavit, exhibit 189. In it, defendant writes, and then had Mr. Duffy execute, which I don't think is in dispute, that that's how this happened. It's also in the materials. Neither Mr. Megaro nor anyone from his office ever gave multi-funding any instructions on how to disperse the money. Neither Mr. Megaro nor anyone from his office ever entered into any agreement with multi-funding with respect to the advances to Henry, Leon, or Geraldine. Any agreement. He was not a party to any agreement or contract, nor did he guarantee, approve, or co-sign the advances. Neither Mr. Megaro nor anyone from his office ever gave multi-funding a lien on any recovery for Mr. McCollum or Mr. Brown. The next paragraph of that same affidavit the defendant drafted, he says, in these subsequent advances, again, Mr. Megaro was not involved in these transactions except to acknowledge the existence of the liens that Henry granted multi-funding as a result of the advances. Based on the documents we just reviewed prior to this violation, it's obviously untrue the defendant never entered into any agreement with multi-funding. However you want to characterize that agreement, I'm sure we can disagree about, but he definitely entered into agreements with multi-funding. We've seen the signatures. It's obviously untrue the defendant never gave multi-funding disbursement instructions. We have the initials. It's obviously untrue the defendant wasn't involved beyond simply acknowledging the existence of the lien. As you heard, we have in our possession, and as an evidence, 216 emails between multi-funding and the defendant. His clients are copied on 8 of them. Is that a lack of involvement? Oddly, the defendant claims this affidavit was for his client's benefit at his deposition. You heard testimony from Henry's guardian that not only is nothing in this affidavit beneficial to Henry, but that it would actually be harmful to him because it suggests he can understand a complex legal document. And again, remember, his case is his inability to understand a document, the confession. Moreover, once again, we need look no further than defendant's own statements to find this statement highlighted here on the screen contradicted. Defendant said in an email to multi-funding when he was trying to get them to either testify or execute this affidavit that without it, he's at a disadvantage. Defendant claims he never used this, but the documentary evidence shows otherwise. He sent this affidavit to Henry's Virginia guardian. He says to her, I also attached an affidavit from Joseph Duffy from Multifunding. He was in Raleigh on December 14th, the day of the last contested hearing regarding Henry's competency. Never got the chance to testify as Judge Boyle cut the hearing short, but he did execute this affidavit, which summarizes what his testimony would have been. What is this if not holding out that this affidavit is accurate? As I understand from the defendant's admissions during opening statement, the defendant has admitted to this violation in O regarding keeping money in his trust account for too long. Therefore, mercifully, I'm sure for everyone here, I'll skip that to save a little bit of time. Move on to N, which concerns the defendant helping Geraldine get a $25,000 loan from Multifunding against Leon's future recovery when she had absolutely no right to that money. This is issue 14 in your list. We know from the materials, this is exhibit 637, that in February of 2016, Geraldine was removed as guardian. Dwayne Gilliam was appointed. Defendant's own notes show he knew about this incident. Again, this is exhibit 117. Defendant's note from March 31st, 2016. Gets a phone call from Geraldine where he says in part, someone is appointed over her to watch the money. The money is no longer in Geraldine's attorney's escrow account. It's in a lawyer's account named Mr. Gillian. Typo there. And that's from March 31st, 2016. And nonetheless, the defendant claims 2 months later, when he receives a letter from Mr. Gilliam, this is the first I've heard about this. Your letter was the first time anyone had told me that Geraldine Brown Ransom had been removed as guardian of Leon Brown's estate. I was completely unaware of this development until I received your letter. He also admits in that same letter that 3 months after Geraldine had been removed as Leon's guardian, and 1 month after he received that phone call from Geraldine saying she's no longer in charge of the money, that he helped her get a loan against Leon's future recovery. He says here he placed her in touch with Multifunding, but as we've seen, he actually did far more than that. He had to sign various pages of the loan contract, which he admits to in his deposition. He initialed those pages of the loan contract. The defendant, I believe, if I understood him correctly, said that he did not know she had been removed. Well, if first of all, we've seen in his own notes that he was certainly on notice that Geraldine was no longer in charge of the money. Secondly, if we had pled it such that we were requiring a knowledge element, it would be just outright theft. As we're pleading it, it's a misuse of entrusted funds, a lack of diligence, lack of competence. For his failure to acknowledge, he allowed someone who had no right to this money to get a loan against his client's future recovery. And what was the result? $38,000 lien. Notice also here that this email was sent only to the defendant, not to his clients. Despite the defendant's claim to this panel during his testimony that he had no idea if loans were actually issued, he received this email. To Mr. Megaro, as you may know, your client took out advanced funds from Multifunding, and we are writing to advise that the balance as of today is $38,000. In the event the case is settling soon, please contact our office for an official payoff letter. Please take a moment to update us on the status of the case. If a major change to the case has occurred, such as a court decision, change of representation, or other major issues, please contact us as soon as possible. We appreciate your business and look forward to doing more business with you in the future. At this point, we stop and ask why. We've seen the defendant approve payments against Henry and Leon's future recovery to Deborah Pointer, Kim Weeks, and Geraldine Brown Ransom. Why? The defendant knows he's got clients here who are easily manipulated and suggestible. He knows that Pointer, Weeks, and Geraldine have control of Henry and Leon. If you keep Pointer and Weeks and Geraldine happy, you keep your access to Henry and Leon. You keep access to Henry and Leon, you have access to their money. Finally, and this is the last section, I'm almost done, I promise. is the allegations in S, which is issue 19. By entering into a retainer agreement with McCollum that was invalid due to his lack of competency, and then arguing that Henry was competent in an effort to protect his fee, despite such arguments potentially harming Henry's then current claims against Robeson County, Red Springs Police Department, the state of North Carolina, and potential invalid contract claims against Pointer Weeks and Multifunding, defendant engaged in conflict of interest. That, I'll admit, is a probably poorly written and terribly wrong sentence for which I accept full responsibility. Here's the bottom line. It was in Henry's best interest to show that his mental deficiencies were accurate. And by arguing at length that Henry was competent, defendant argued against Henry's interests. As a reminder, the defendant himself presented multiple slides showing that Henry was mentally retarded. And again, all for the purpose of showing that Henry couldn't understand the confession he signed. That was the case, not just a part of it. Defendant had also pled that Henry couldn't understand spending limits. He couldn't understand budgeting his money. He couldn't handle his affairs. Defendant's own expert cited Dr. Richard Rumor saying that Henry's confession was well above his level of literacy, a conclusion affirmed by defendant's other expert, Dr. Bellard, in this very hearing. Dr. Harbin also said that Henry will be overly dependent upon others for decision-making, will be overly influenced by others, will lack self-confidence and assertiveness, and will be easily influenced and manipulated by others. Dr. Harbin also said Henry will be unable to make everyday decisions. He said Henry is unlikely to ever recover significantly from the severe distortions to his development and life skills. He said Henry has post-traumatic stress disorder and mild intellectual disabilities. And again, why would the defendant use this expert opinion for Henry? Because it was in Henry's best interest to show that he was mentally unable to understand his confession. Defendant's expert wasn't the first to evaluate Henry. Dr. Richard Rumor did. Helen Rogers did. Helen Rogers did again. And Faye Sultan did as well. And what did these experts conclude? Let's look at just a few snapshots. Besides his mental deficit, Mr. McCollum is strongly suggestible and susceptible to peer pressure. He possesses limited reasoning capability and thus relies on others rather than exercising his own judgment. Mr. McCollum's scores demonstrated that he has significant sub-average intellectual functioning that fits within the definition of mental retardation and places him in the lowest 2 to 3% of the population in overall intellectual functioning. Lowest 2 to 3%. Mr. McCollum's language skills are very compromised. He has great difficulty identifying the name of a common object, even if he can describe it. So there we see both written and oral language skills are deficient. Mr. McCollum showed that he is highly suggestible and subject to the influence of others, particularly authority figures. Mr. McCollum scored in the lowest 0.6% of the population on reading and arithmetic. What skills do you think you need to understand a retainer agreement or a settlement agreement or a loan contract? Arithmetic and reading. Mr. McCollum's decision-making ability is severely impaired. Even with thorough explanation and careful probing, Mr. McCollum generally is not capable of understanding and weighing the consequences of his choices. Why did the defendant present all those PowerPoint slides and get an opinion from Dr. Harbin that said Henry's unable to make everyday decisions and easily influenced and manipulated by others? Why did Henry's attorneys throughout the years present expert evaluations showing Henry's intellectual disabilities? Because that was the case. That's in Henry's interest to show that, yeah, in fact, he cannot understand things. Defendant himself admits at his deposition that the reason to present that evidence is to establish that Henry couldn't understand the confession he signed. Defendant said by presenting that evidence, he wanted to emphasize the limited intellectual ability in order to establish the claim that they were wrongfully convicted and coerced into signing false confessions. The intellectual disabilities equal false confessions. Defendant himself admits that. Defendant admits the evidence of Henry's mental deficiencies were a big part of his 1983 civil action. Why did you feel the need to present that as part of their case? Because that was part and parcel of the claims advanced in the 1983 action. The defendant also draws a distinction between good facts, that is those showing Henry's retardation, and bad facts, those showing Henry wasn't mentally deficient. I said, are you claiming here that these doctors and experts who examined and tested Henry throughout the years all consistently indicated that he was mentally retarded? Yes, those are the good facts. Said he wanted to play down the bad facts. I asked, when you say they're bad facts, like facts that are contrary to this, that is Henry's mental retardation, would hurt your client's case? And he says, correct. I said, so if someone were to present evidence contrary to this, it would be harmful to Henry's case? He said, that's correct, yes. Then he said, that's something I would do if I was a defense lawyer. That is a lawyer on the other side of the case where Henry was the plaintiff. So if he was Henry's opposition, that's what he would present. Defendant also explains why he was making this argument. Because the state, that is Henry's opposition, those he was suing, they were arguing that Henry could understand his confession. Defendant's own words, what I was trying to do is I was trying to dislodge them from their position that Henry McCollum had no intellectual disability whatsoever and that he fully understood the ramifications of his Miranda waiver. And if you take those facts and that plus that equals the conclusion that the confession was not coerced and was not false and was therefore correct. And therefore the defendants are not liable for false arrest, false imprisonment, malicious prosecution, so on and so forth. He's trying to dislodge them from the notion that Henry could in fact understand his confession. So to show the confessions were false, you show their mental retardation. You show that they couldn't understand what they were signing. They couldn't understand a written document. I asked defendant, so that would be harmful to Henry's case if someone were to argue that he was not mentally retarded? And he said, of course. I'm not going to say that. See that there, line 5 and 6? I'm not going to say that, he says. Well, it turns out when this contract, this retainer agreement was at issue, that's exactly what he said. But there's no evidence that Henry Lee McCollum is mentally retarded. And there's no question that what was at issue there was the defendant's retainer agreement. The court specifically said, I think the first order of business before the court in the McCollum versus Robeson County is the competence of plaintiff McCollum to make decisions and enter into legally binding obligations. You heard testimony noting that legally binding obligation at issue was the retainer agreement. Defendant's arguments in this regard, wherein he says, I don't believe that Mr. McCollum needs a general guardian because he has been living on his own and managing his own affairs for close to 3 years now. That was the view I put forth before the court on May 5th. That's the view I put forth before the court in my submission. And that's the view I put forth before the court here today. Defendant's arguments in this regard were so obviously contrary to his client's interest that the court asked him about it. You believe you have a conflict of interest? He said, absolutely not. I have no conflict of interest. You heard testimony from Henry's attorneys, and Leon is there with the glasses, Henry without the glasses. You heard testimony from Henry's attorneys about how harmful the defendant's arguments were in this regard, particularly since he made them at a time when he admits the state was still claiming that Henry was guilty and that his confession wasn't false. You heard testimony showing that the only folks throughout the year presenting arguments that Henry could understand documents were his opposition. The state, when they were trying to convict him, when they were trying to execute him, when they were trying to keep him in jail. And then when Henry got out and sued the town, sued the state actors, they were the ones claiming it. Only Henry's opposition was claiming that he could understand documents, except until his own attorney did. So let's summarize. Defendant has 2 individuals who he knows are mentally deficient sign a predatory contract with him. He steals their money both through excessive fees and by taking portions of their awards to which he had no right. He makes multiple misrepresentations to multiple courts. He manipulated these men and took advantage of them for his own gain. When the court called him on it, instead of protecting his clients, he protected himself and made arguments directly against his client's interests. Either that is acceptable conduct for lawyers or it's not. Your decision will tell us which. This case is about predatory men who took advantage of vulnerable, mentally challenged victims and manipulated them for their own interests. That's what happened in 1983, and that's what happened in 2015 at the hands of the defendant. Sadly, it's too late to give these men justice for what happened to them in 1983, but it's not too late to give them justice for what happened to them at the hands of the defendant. We respectfully request that this time you give these men justice by finding by clear and convincing evidence each of the rule violations listed in the amended complaint. Unless there are any questions, I'll submit the case.
Mr. Bennett, any questions?
Yeah.
Mr. Morris? Thank you, Mr. Walpole. I don't think we'll have any questions.
Thank you.
Let me just say before we begin our deliberations that I have attended a number of these, participated in a number of the panels regarding these cases, and I must compliment both sides. The advocacy for both Mr. Megaro and for the State Bar has been outstanding. Both sides have been well represented in this hearing. I think the panel's in complete agreement about that. So.
I wholeheartedly agree with that.
Thank you.
All right, we'll be at recess. As I indicated to you earlier, we have to break at noon for other matters that we have. But we will begin our deliberations and just ask folks to stand by while we do that. All right, we're at recess. In our discussions as a panel, we just reiterated among ourselves what a well done job on both sides. We compliment everyone in that regard. I would like to go through the plaintiff's issue list. So if you have that in front of you, I tend probably to do this by just numbered issues rather than read the issue unless someone actually wants me to read the issue, which I can do.
That's fine, just by number.
All right. And working off the plaintiff's issues list, issue number one, the panel found that the State Bar had met its burden of proof as to issue number one. As to issue number two, the panel could not really distinguish the difference in issue number two and issue number one. Therefore, we did not address that, and we will not be addressing issue number two. As to issue number three, we found that issue was not proven by clear and convincing evidence, and that therefore is in favor of the defendant. We did not find clear and convincing evidence as to issue number four, or issue number five, or issue number six. As to issue 7 and 8 and 9, we felt that the State Bar didn't meet its burden of proof and found in favor of the state. We did not find the state met its burden of proof as to issue number 10. We did find that the state met its burden of proof as to issues 11 and 12, 13, 14, 15, and 16. We found that the State Bar did not meet its burden of proof by clear and convincing evidence as to issues 17 and 18. As to issue 19, the panel struck the words that began "and potential invalid contract claims against Pointer and Weeks." We struck the rest of that paragraph, but we did find as to the first part of that paragraph that the state made its burden of proof by clear and convincing evidence. And as to issue 20, we found that the State Bar did not meet its burden of proof by clear and convincing evidence as to issue 20. That'll be the finding of the panel. In light of that, Mr. Williamson, will there be evidence as to phase two?
Yes, there will.
All right, sir. We're ready to proceed if everyone else is.
Then it go first necessarily.
You know, I don't know the answer to that question. Do you, Mr. Walthall? I apologize for my lack of procedural knowledge on that point, but I don't know the answer to that question.
The State Bar does not have any phase two evidence, so.
That makes it easy. I don't have to figure
Okay.
that out.
Okay. Could I have just a moment?
Yes, of course. So this from here to here struck out, right? Here, okay.
Mr. Chair, just for the record, just to make sure this is there, we do want to point out that we did submit evidence during the phase 1 time that would be phase 2 evidence.
Yes,
Just to clarify,
and
we have no
we-
additional evidence at this time.
All right, and also I need to make a slight correction on, Mr. Bennett reminded me on issue 19. I want to read into the record the entire issue that we addressed, leaving out the portion that we omitted. Issue 19 reads, did defendant by entering into a retainer agreement with McCollum that was invalid due to McCollum's lack of competency, and then arguing that McCollum was competent in an effort to protect his fee, despite such arguments potentially harming McCollum's then current claims against Robeson County, the Red Springs Police Department, and the state of North Carolina, engage in a conflict of interest as defendant's representation of McCollum was materially limited by defendant's personal interest in defending his fee in violation of Rule 1.7. I think I said that, took too much out in what I just recited earlier, but I think that's what we decided. We have to take as much time as you need, sir, but if you're ready, we are.
I believe we're ready to go.
All right, sir.
We would call on phase 2. We're actually going to call 2 witnesses. First would be Maria Pendraza. And she'll spell that for the court reporter.
Ms. Pendraza, if you would, ma'am, please place your left hand on the Bible and raise your right hand and face the clerk right here. Excuse me, do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, ma'am, if you would just have a seat.
Do you need to spell my name? It's P as in Peter, E, D as in dog, R, A, Z as in zebra, A.
All right, Ms. Pedraza, what is your full name and residence address?
Maria Antoinette Pedraza, and I live at 305 Cattell Avenue, that's Cattell, in Collingswood, New Jersey, 08107.
What's your occupation?
I am a federal public defender at the Federal Community Defender Office for the Eastern District of Pennsylvania out of Philadelphia, Pennsylvania.
And how long have you done that?
I've been at that office for about 8 years.
And you must be a licensed attorney.
I am. I'm licensed in New York, New Jersey, and Pennsylvania, and the federal court, the Eastern District of Pennsylvania and the Eastern District of Missouri.
And are you in good standing in all those places of your licensure?
Yes, sir.
You know Mr. Megaro?
I do.
Okay. How long have you known him?
I believe about 20, maybe 22 years.
When did you first meet him?
I first met him in law school. We both went to Hofstra together. When he started as a 1L, I was a 3L. And then I graduated, and then we crossed paths again in 2002 when we both started working at the Legal Aid Society in New York City.
And could you tell the panel what the Legal Aid Society in New York City is? Because we call it something different here.
The Legal Aid Society is a nonprofit organization that was created in I think it was like the 1800s. It was one of the nation's first public defender offices. And it's an organization that has a contract with the city of New York to provide public defender services in the 5 boroughs.
And is that exclusively on criminal matters?
Yes, it is. Misdemeanors and felonies.
And in your working there, did you have the opportunity to observe Mr. Megaro's work?
Yes. And not just while we were at Legal Aid, thereafter as well.
Okay. And if you could describe that.
So we started together at the same time. We were one of the largest classes that was hired by Legal Aid So we went through a very rigorous training process before we were allowed to take cases together. So we spent, I think it was probably about like the first 2 months in seminars together daily, doing run-throughs and mock arguments, mock trials, mock closings, things of that nature. So we watched each other and we gave each other feedback. I remember Rick being very involved, very proactive, very dedicated to the work, very eager to learn and take criticism and adjustments from other attorneys, including colleagues that were starting with him, as well as our trainers. Once we were in court, as you can imagine, we hit the ground running. After training, we were put right into arraignment sessions, both night court as well as during the day, and immediately started trying cases and doing hearings. And Rick was always right at the forefront, making sure that he was prepared for all these cases, and which is difficult. We juggled, as you can imagine, a very, very large caseload. And he was always prepared, always willing to sit down and talk to colleagues. We used to refer to it as law by consensus, just kind of, we would sit and talk amongst ourselves about how we should approach cases. And he was always a great sounding board for me and for others at Legal Aid.
And in what time frame were you together at Legal Aid Society?
From about 2002, I left, I believe, in 2004, 2005. And he remained after I left. And we kept in contact.
And did your paths cross professionally at some point after that?
Yes. I don't know exactly when, but Rick went out in private practice. And at that point, I was actually in private practice as well. And he had been retained on a multi-defendant case in the state of New Jersey, which is where I was practicing at the time. And he contacted me or put me in contact with one of the co-defendants who was needing an attorney. And that client ended up retaining me to represent him on that case. And so it was a fairly protracted litigation that involved many, many different motions. And so we worked on that case together. I think that case was about, I want to say at least a 2-year long representation, but I could be wrong about the time frame, but it was definitely a very long time.
What was the year or years of that case, if you recall?
I don't recall. I'm sorry. I left private practice to go back into being a public defender in 2013. And my partner retains the practice when I left, and I know that he took over the representation of that client after I left, so it was still going on around that time.
And during all this time,
I'm sorry, it wasn't 2000, it was 2010. My apologies.
no need. During this time that you were professional colleagues, would you also consider Mr. Megaro a friend of yours?
Yes.
And have you remained friends through the years, even though you're geographically separate? Yes,
I think we've always been friends. I've interacted with him and his wife and his children. He knows I love baseball. I went down to where he lives, and we went to Port St. Lucie and caught a spring training game. I think one of the great things about our relationship as friends is that we have been able to keep in touch. We've both put in the effort to keep in touch. And so we've kind of seen each other evolve through like so many different phases of life, both personally and professionally.
In the course of your knowing him both as a colleague professionally and as a friend personally, have you had the opportunity personally to observe his character as a person?
Yes, I can say without hesitation that I look up to him as an attorney. I think that he's been able to accomplish many things on behalf of clients that most attorneys can only dream of doing. I've represented thousands of people in 3 different states and federal court. And I can only hope to one day achieve some of the things that he's been able to achieve that I know the panel did hear about, in terms of helping people in ways that just can't be measured. He's an amazing father. I've seen how devoted he is to his sons and his family. He embodies what I think to be what we want the profession to reflect, somebody who can be zealous and be devoted in both aspects of their lives. I don't think that even for a second anyone can say that as devoted as he is to his profession, that's in any way caused his personal life to suffer. He manages to balance all of that. And it's really amazing. He's for me, he's a friend, but he's also a role model. I think that he is an amazing person.
Have you also, through the years, had occasion to be aware of his reputation in the legal community where you practiced with him? Is that a yes?
Yes, it is. Well, obviously, so I practiced with him directly, both in New York and New Jersey. In New York, we were in criminal court, which is the misdemeanor level. We were also in Supreme Court, which was the felony level. And he was always prepared. People knew what to expect. I think prosecutors knew that they had to be ready, that Rick was going to represent his clients and was going to hold them to their burden. It was the same in New Jersey. I know he's gone nationwide and has made appearances for people in different courts, something that I don't anticipate my career lending itself to, but he has done that effortlessly. And I think that's a testament to how strong his character is and how much of an asset to our profession he is, that he's able to go anywhere and achieve positive results for his clients. I say that without hesitation.
Do you believe that your opinion of his reputation and character is shared generally among other members of the profession?
Absolutely. I've seen other attorneys go to him for advice. I've seen other attorneys, as I said, consult with him to get ideas, and he's receptive in kind as well on cases. So he absolutely is held in high regard, and is somebody that other attorneys will turn to for assistance without hesitation. I've heard of attorneys seeking him out to cover cases for him. Obviously, attorneys can be very protective of clients. A lot of times I'll spread myself thin just to make sure that I don't have to ask another attorney to cover a case, but because I'm worried about it. But I would have Rick cover a case for me, and I know other attorneys have and would continue to do that because he can be trusted.
Have you been here earlier during this hearing?
Yes, I arrived in Raleigh on Wednesday. So I was here all day yesterday and today.
And as you sit here today, would you have any hesitation to working with Mr. Megaro again if your professional paths crossed again?
No, and I would welcome it. And I hope that one day we do have the opportunity.
Is there anything else? I'll just ask you the open-ended question that you would like to tell the panel about Mr. Megaro.
I think that we all become attorneys to help people. We become attorneys because we want to do good for the public. And I think that the panel has so much evidence of all the good that Rick has done in his life, that Rick has done throughout his career. I expect that you're going to hear from one of those clients who was positively impacted by his advocacy and his skills as an attorney. And I would ask that you just remember that he is why we become attorneys. We become attorneys to help people, to correct injustices, to make sure that wrong is not done. And I think that he has done so much that should not be overlooked. And I would ask that you consider that and give it great weight.
Thank you, Ms. Pedraza. It's possible the panel or the State Bar may have questions for you.
Any cross-examination?
Ms. Pedraza, my name is Pat Murphy, along with Josh Wathall. We are represent the North Carolina State Bar in this proceeding.
Hello.
You have been here since Thursday, so you heard testimony Thursday and today. So most of the testimony you heard was from Mr. Megaro's side of the case.
Correct.
Do you
And
know?
I heard closings.
Okay. Do you know anything about the facts of his representation of Mr. McCollum and Mr. Brown, other than what you've heard here in the courtroom?
I did look at some of the documentation associated with the case. I'm not sure.
Excuse me, go ahead.
No, I just that beyond that, that's where I would have information from.
And when did you look at that?
Probably the week before last or so. I don't recall exactly the date.
And why?
Just in preparation of coming down here.
And what did you know? What did you learn about the case from what you looked at?
I'll be honest, it was a lot of stuff, so I didn't look at all of it. I just had too much on my plate to give it the full consideration that I think both parties clearly have. I knew of the situation. I've known of the situation for quite some time. I don't know that I learned much more than what I already knew, but I did look at some materials.
And when you say you've known about the situation for quite some time, put that in context. Who did you learn from, and what information do you have about Mr. McCollum's and Mr. Brown's situation?
Well, I started learning about the case when I found out how they had been wrongfully convicted and were sentenced to death despite not having committed an offense. So I knew about that from the beginning. I knew about the efforts that went into the exoneration process, and obviously the efforts regarding compensation for time that they wrongfully spent in custody. I then learned about the pendency of this matter because Rick had said he was coming up to North Carolina, and I inquired as to why. And so he told me, and so I knew that this was pending. So that pretty much kind of what I.
Have you represented clients before with IDD or emotional or mental disabilities?
Of course, it's unfortunately a byproduct of being a public defender.
And people with those mental or emotional conditions, are they often vulnerable?
I mean, I think you can't sweep a brush over that. There's many different levels of intellectual disability. There's many different levels of mental illness. And I think perhaps one of the biggest dialogues that's been going on of late has been a dialogue regarding mental illness and how it can impact people, but also how people can work through it. Obviously, intellectual disability is something that we deal with a lot as well. I deal with a lot of people who are on the autism spectrum. So there's a lot of different ranges of capacity there. I have had clients who have tested as on the mental retardation scale. And And I think that obviously everything is a case by case basis. You can't make generalities in terms of how someone can carry on their lives. So it is, I think, very case by case. I don't think that you can ascribe a certain conclusion simply because somebody exhibits some deficiency.
Do you know anything about Mr. McCollum and Mr. Brown's situation? Their
Can you be
their
more
mental or
specific?
emotional disabilities?
I believe, from what I understand, I think one of them is intellectually disabled, not the other, which was widely discussed here today and also yesterday. But I'm not, I didn't review any reports relating to testing or anything that was done in association with those conclusions.
Are you aware that the hearing panel has found that Mr. Megaro entered into a representation agreement with his clients when he knew they didn't have the capacity to understand the agreement, by doing so, engaged in conduct involving dishonesty, fraud, deceit, and misrepresentation in violation of North Carolina Rule of Professional Conduct 8-4C, and by engaging in such conduct, engaged in conduct prejudicial to the administration of justice by having done so. Do you realize that he's been found to have violated those rules?
I understand that my testimony is not obviously with regard to whether the panel's decision was correct or incorrect. Obviously, I'm here with respect to what action should be taken as a result of that conclusion. And again, I would just implore the panel to please look at the bigger picture of all the good that Rick has done in his life and throughout his career in addressing things. And I think that even with that conclusion, bearing in mind that Rick was able to get 2 innocent men off of death row, that is something that I think far outweighs the panel's conclusion, and should definitely be weighed more heavily in terms of determining how to resolve the punishment aspect of it.
Do you call Mr. Megaro Rick?
Yes, that's just a nickname. Yes,
And
sorry.
And it's your understanding of the facts that Mr. Megaro, got Mr. McCollum and Mr. Brown off death row?
Well, I think there was my understanding was that there was a process in terms of the exoneration with the governor.
Yeah.
But even I think that's just the tip of the iceberg in terms of also the work that Mr. Megaro did with a witness that I believe you're going to hear from next, as well as another man from the St. Louis area who he assisted tremendously upon showing the great strides in rehabilitation that he had taken in his life.
So it would be fair to say you know very little about the facts of this particular case that the panel's been hearing all week.
I don't know as much as you,
Okay.
but I do know what I've heard here yesterday and today. Obviously, I don't think anyone knows as much as the parties and the panel, having had the benefit of sitting through the last week of testimony. I can tell you what I know about him from my almost more than 2 decades of friendship and professional affiliation with him, and my view of the value that he brings to the profession.
When was the last time you had any professional association with Mr. Megaro?
As I stated, the last professional affiliation that I had with him would have been around the fall of 2010, which is when I left private practice to resume and take a position with the New Jersey Public Defender's Office.
Okay. And so that's would that be the last time you had been around him in the same legal community as Mr. Megaro?
No.
Okay.
No, because we've maintained contact. We've seen each other. I don't know how many times since then. We talk on the phone from time to time and always talk about cases. I've had the opportunity to interact with him together with other attorneys and other colleagues that he does share the profession with. So including his partner. So I have had I guess you could call them personal, professional interactions, in the sense that we are not in court, but we are talking about cases and talking about legal procedures and strategies.
And that legal community would have not been amongst the North Carolina bar, correct?
No,
So it
no,
would have been the New Jersey, Pennsylvania bar, Florida bar.
right. And obviously, all practicing attorneys from all different courts, handling all different kinds of cases that are similar to the ones that Mr. Megaro handles.
That's all the questions I have.
Any redirect?
No, sir.
Mr. Morris? Bennett? Thank you, Ms. Pedraza. You may step down. We do ask witnesses to wipe down the area that you've been in, please. Just as an abundance of caution. It's fine.
Okay.
Thank you very much. Appreciate your participation. Will there be other evidence for the defense in phase two, Mr. Williamson?
Yes, one other live witness, Mr. Corvain Cooper.
All right, Mr. Cooper, come around, please, sir. Mr. Cooper, if you would, sir, place your left hand on the Bible and raise your right hand and face the clerk. Do you solemnly swear the testimony you're about to provide to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, sir, please have a seat.
Good afternoon, Mr. Cooper. Could you tell us your full name and where you are currently residing?
I'm Corvain Cooper. I was just serving life without the possibility of parole.
No, where are you residing?
Oh, I'm residing in Los Angeles, California.
All right. How long have you been residing in Los Angeles, California?
For my whole entire life, but for the last 59 days.
Right, for the last couple of months.
Right.
Where were you residing before then, immediately before then?
I was in Pollock, Louisiana, serving life for marijuana.
Has Mr. Megaro represented you as an attorney?
Yes, sir.
And in what cases he represented you?
He represented me in my case where in Charlotte, North Carolina, I was serving life without the possibility of parole for trafficking marijuana and money laundering.
And when were you convicted of that?
I was convicted in 2013 and I was sentenced in 2014.
In connection with that, did Mr. Megaro represent you at your trial?
No, Mr. Megaro was hired originally from the Brown Stern law firm, and he represented me at sentencing and on my direct appeal.
Was that sentencing before Judge Conrad in the Western District?
Yes, sir.
Do you have an understanding as to why you were sentenced to life for a marijuana charge?
Yes, sir.
What is your understanding?
My understanding was that I had 2 prior convictions, and with the 851 enhancement, with the federal law, you have 3 felonies. It's like a 3-strike type of situation where on your third one, you will get a life sentence.
And what were your 2 prior convictions?
One for a half a pound of marijuana. And my second one was for a bottle of cough syrup.
At your sentencing before Judge Conrad, do you recall him expressing some concern about how you had to be sentenced?
Objection.
Overruled.
Yes, he stated that it was very hard on the court to give a 34-year-old man a life sentence without the possibility of parole.
Now, once you were sentenced, did Mr. Megaro continue to represent you?
Yes, sir.
What did he do on your behalf after you were sentenced?
After I was sentenced, we started our direct appeal with Brownstone. We had
Brownstone, was that the name of the firm he was with at the time?
that was the name of the Brownstone law firm. Yes, that Patrick McCollum was working for when we originally hired him.
Okay, go ahead.
When we started the process, he was going through the process of him leaving Brownstone and opening up his own law firm. So it was like a pivotal decision that had to be made at this point where I had to pick through Brownstone or go with Patrick. When Patrick met me, we vibed right off the bat where he had 2 kids, I had 2 kids. We're around the same age. I'm 41 years old today. So our lives were like parallel. And he always told me that. And he was like, I'm gonna get you back home to your mom. I'm gonna get you back home to your 2 daughters. And as when Brownstone calls and they say, well, Patrick's leaving, you're gonna have to pick Patrick or you're gonna have to pick through us. So I talked to my moms. I said a lone prayer, and I said, I got to go with Patrick. I just really feel that Patrick is the one that's going to really get me home. And during the time that we had to go through the pivotal pick of Patrick, we run out of money. So we don't even have any money. And I picked Patrick, and we've ran out of money. And Patrick said, I made a promise to you. And I'm gonna fight your case pro bono. I'm gonna fight it myself. I'm gonna get you back. And we start going through all the processes of the direct appeal and getting denied and keep fighting. And now it's time is just passing by, and all we're getting is just denied, and my life is on the line. And we get to 2016. As 14 and 15 has passed now, we're at 2016 now. And it gets even more, we're thinking that it's getting better for us, but it's getting worse because we put in a petition with the Obama administration, we get denied.
A petition for a pardon?
A petition for a pardon, so with the Obama administration. But during the time we're putting in a petition, I'm like the campaign for Prop 64, since I'm from California, my prior is for marijuana. We think, wow, this is the break that we need. You know, you got the marijuana case, I got marijuana, we get the prior taken off, we get it taken down to a misdemeanor. He files the Prop 47, we get the codeine taken down.
Using a little bit of lingo here, that if you could explain what you mean a Prop 47.
Prop 64 is a law in California where if you have a felony for marijuana, they would drop it down to a misdemeanor. And they dropped it down to a misdemeanor after we filed the petition for that. And then we filed a petition for Prop 47 for the codeine to get filed down to a misdemeanor. So now all we wanted to do was go to the court and ask for time served or just to get resentenced with the Supreme Court, because I no longer have the priors felonies that got me the life sentence. And we still
What happened with that effort?
with that effort, we still got denied. He kept fighting though for me. I mean, he kept putting in papers. He kept fighting. He kept fighting. And we got denied all the way at the Supreme Court. We made it all the way to the Supreme Court where they answered us back, and we still got denied. So now our future is looking dang. Now Obama's leaving, but Trump is coming in. And so now he said, I'm just gonna go out on a limb. So Patrick just went all the way out on the limb, and he wrote the clemency for my petition himself. And he asked Trump, he said, you asked Obama, but I'm going to ask Trump as me being a citizen, as me being a person of the United States. I'm going to ask him to do this for my client, to get you back to your family on the change.org petition. And when he wrote the change.org petition, I read it to my cellie, and my cellie just bore out in tears, you know, because it was just such a hard. My cellie just broke down in tears when we just read it together, and we just both cried.
Use a little bit of lingo there again. Your cellie, I think I know what you're talking about. But.
Right, my cellmate at the time, when Patrick mailed it to me and asked me what did I think about it, we just both broke out in tears, like when we read it, because it was really from the heart. And if anyone reads it today, I think you'll break out in tears just to see a man. He's asking Trump. I'm not asking him. He's asking him for him to please let his client out and back to his family. This is when the change.org. So as soon as it hit, we got 40 to 50,000 signatures, like in the first 2 months. Yeah. So after that, we keep fighting. Now we're getting more media coverage, more activist groups are reaching out because of this. And we still got a long shot. We still got a long way to go, because now it's 2017. We may be at about 70,000 signatures now in 2017. And we're steadily moving up the chain. He does a video about it, and then he asks Trump again. And that goes viral. And we're steadily pushing. He's steadily pushing for me. He's steadily putting paperwork. We're trying compassionate release. We're trying this. We're trying that. This is all pro bono work. This is not with $1 on the line. And he's pushing for me. He's pushing. I'm steadily writing. He's even calling in my family and calling me and checking on me when I'm on lockdown. And whether what I'm going through, I'm going on 3 or 4 months lockdown, and I can still get put out and get called and checked on by my attorney. So I'm having the faith. Now it's 2018. And time is steadily pushing. It's steadily going. I got life without the possibility of parole. Trump is going through things. We're going through things. And now 2019 comes. So now the window is closing, because clemencies happen when a president leaves office, not when he comes into office. So as 19 closes in, it's like your hope is really like you're losing hope. But I'm always writing Patrick, and he's always writing back. I send him Father's Day cards, and I'm just saying, like, man, I think we're going to do this. And I'm really just having my hope, because if you look up a person that has life, it says deceased. So it's just like you're looking at somebody else was just on death row. So as we get to 2020 and it's winding on down, as everyone knows, you know, you got Trump has this capital thing going. You got everything that's going on. You got the walls closing in even more, because you're dependent on a president that's going through his own struggles and is going through his own stuff. And as this is going on, if you look up December 29th, front cover of the New York Times, my attorney, Patrick Megaro, is still fighting for me. It's on the front cover of the New York Times, where he's arguing with Trump, how you gonna get your friends out, leave Corvain Cooper in there. This is so, when you're in prison and you see this is on black and white paper. This is New York Times front cover. I'm reading this like, damn, my attorney's still fighting for me. You know, the walls closing in, you see the Capitol thing, you think you have no more hope, but then here comes Patrick Megaro giving me more hope. Now it's January. It's 2 more weeks. It's getting towards the end. You feel me? If you don't know if Bible's not going to come in and do clemencies, so you maybe got 8 more years or 4 more years that you got to sit in just to put in another lottery ticket, because the only thing that can get me out is a lottery ticket, or the law can change. So we get to the 20th, and we're at the last second. I don't see my name on the list. On the bottom, I'm asking the people in jail, like, do you see my name? I'm looking at NPR, I'm watching the radio. I don't see it. So the next thing I know, they come early in the morning and say, man, pack your bags, man. You're leaving early in the morning. You know what I mean? Pack your bags. So I call my mom, she's crying. She says, she talked to Ivanka Trump at 12:30 and said, that you're getting out, you got clemency. I get the papers. And not only did Patrick Megaro deliver on his word, he picked me up and physically, not words, take you back home to your mom. This is all on tape. This is CBNC News. Delivered me home to my mother like he said he was going to do. Picked me up from prison and took me on a flight and flew me home back to my mom's literally with his own hands. It's like, this is nothing that you can write. These are facts. And this man has been so, just to be able to touch my kids and be with my kids again, I'm like a living reason of like what this man is really about. It's just a lot, man. It's just this man has done so much for me and my family that I can't say it in words.
Cooper, did Mr. Megaro deliver on the promise he had made to you all those many years ago?
Yes, he did. And to my mother, not just to me, to my mother. He physically delivered me home to my mother.
And he did it pro bono?
Not $1, not $1.
How do you feel about Mr. Megaro today?
I love him with all my heart.
You've been here. Have you been here for the whole hearing?
I've been here for 2 days.
Okay.
And I'll be here for 20 more days if he needs me.
Don't believe it'll be necessary. But, you still feel about him today as before you came here?
I feel even better about him. He's a part of our family. He's part of my family now. My mother's called 3 times just to check on him.
Is there anything else you want to tell the panel about Mr. Megaro?
I just want to tell him that he brought me and gave me my life back. He never gave up on me. He didn't do this for money or for fame or for nothing. He did it because me and his life was parallel. And I have 2 daughters and he has daughters. And he really wanted to see me back with my family. And he stood on his word and he did that. And he maybe had to stop and close his office down just to come get me from prison and make sure he delivers me back. And who knows what he had to stop doing in order to even do that at that time. But he's a man of his word, and everything that I'm saying here are facts.
Thank you, Mr. Cooper. Somebody else may have some questions for you.
Will there be cross-examination?
Yeah, Mr. Cooper, my name is Pat Murphy, along with Joshua Walthall. We represent the North Carolina State Bar in this matter. Did you plead guilty or were you convicted of trafficking marijuana?
I was convicted.
Okay. And that was in Charlotte, North Carolina?
Yes, sir.
And what year? Was that 2013?
Yes, sir.
So you actually,
October 18, 2013.
and you actually went to a trial?
Yes.
And a jury convicted you of that?
Yes.
And Judge Conrad was the presiding judge at your trial, correct?
Yes.
And then under the current law, I guess the 3 strikes law, you had 2 prior felony convictions, and this would be your 3rd. And so under federal law, you got a life sentence. Is that correct?
Yes.
And you were not being represented by Mr. Megaro during the actual trial?
No, he came at sentencing.
Okay. So who was representing you at trial?
Diane McFay.
And was she with the Federal Public Defender's Office?
Yes.
And was there some pause between the conviction and the sentencing? Or was there an appeal in between? I wasn't quite sure.
He represented me on direct appeal, but I guess you can say it's a pause because we fired her and then hired the Brownstone law firm. And then Patrick came on. With,
Who
to my
fired,
sentencing.
who fired the public defender's office?
My mother.
Your mother did. And where does your mom live?
She stays in LA too.
In LA, she's in Los Angeles.
Yes.
And you're there now?
Yes.
And so Mr. Megaro was working for the Brownstone law firm, and you hired them to pursue a direct appeal.
Yes.
And Mr. Megaro handled that, correct?
Yes, he started the process, but then he moved on to get his own firm with
Right. And when he left the Brownstone law firm, he continued on your case and you wanted him to.
Yeah, I had to pick between him and Brownstone, and I picked Patrick.
Okay. And your direct appeals were all denied?
Yes.
And when were the final direct appeals denied?
2014.
And at that point, were there any other appeals that he pursued on your behalf?
He did a direct appeal. He did a 2255 motion.
That's a habeas corpus proceeding.
Right. He's done a ton of motions.
And the habeas corpus proceeding was not successful.
Right. Nothing was successful. But the clemency that he wrote, we had 151,000 signatures.
And so then he started pursuing clemency on your behalf, right?
Yes.
And began under the Obama administration.
Yeah, we got denied under Obama administration. So we went back with Trump, and he wrote it up himself, and he asked Trump under Patrick Megaro asked Trump on the change.org, can you please let my client out?
And did you get, what was the relief that you got? Do you know?
I got executive clemency. I didn't get a pardon. I got executive clemency.
And what's the difference between a pardon and clemency?
A pardon, you're totally forgiven for your crimes. Clemency, you're forgiven, but you're still on parole and probation.
Okay. Are you currently on any type of supervision from federal courts?
Yes.
Okay. And how long will that last?
10 years.
But you're not in prison, correct?
No.
Yeah. How long have you been sitting in on this proceeding?
For 2 days.
Do you know anything about the facts of this case other than what you've heard here today?
I've just been listening for the last 2 days and just trying to take notes and stuff like that.
But you don't know anything else about what happened with regard to Mr. McCollum and Brown, other than what you heard in this courtroom?
Right.
All right. No further questions.
Any redirect?
No, sir.
Mr. Morris?
I'm good.
Mr. Bennett?
No, sir.
Thank you, Mr. Cooper. You may step down, sir. Will there be further phase 2 evidence for the defendant, Mr. Williamson?
If I may have a
Of course,
moment.
of course.
Mr. DeVore, we don't intend to call any more witnesses, but in recognition of the lateness of the week and of the hour, I would like to note for the record that we have some other folks here that we had contemplated calling who are here to support him, and just have on the record that they would be available to call if in our discretion we thought it was a good thing to do, but again, given the late afternoon.
Is there any objection to him identifying those witnesses that are here from the state bar?
No.
Okay. If we could, just stand up and speak loudly and identify yourself and identify what, what connection you have with Mr. Megaro.
My name is Anthony Allegretti. I was friends recording. I am friends recording of 27 years in freshman year of high school. and I was his main advocate during this whole time that he was in prison. And I had direct communication. Pretty much.
I thought we did.
Yeah,
identify-
we're getting,
Jump into a lot of detail. Mr. Russo.
Good afternoon. My name is Jason Russo. I'm an attorney from New York. I've known Mr. Megaro since 2004 and have worked alongside him on numerous criminal defense matters at that time up until present.
All right, thank you, Mr. Russo.
Good afternoon, everyone. John Campo, I'm an attorney. Hired me as an intern at the
Thank you, Mr. Campo.
Would be the showing on phase 2 for us.
All right. State Bar.
no evidence, sir.
All right, sir. At this point, Mr. Walthall, how do you wish to proceed? Or Mr. Murphy?
As I understand, the defendant has put on evidence in phase 2, therefore we are permitted to go last. And so we will once again waive first phase 2 closing and conclude the hearing.
That was my question.
Yes, sir.
All right, Mr. Williamson, are you prepared for your closing, or do you need a moment or two?
Can I have just several minutes?
Sure. Why don't we take a 10-minute break? Is that sufficient, Mr. Williamson?
Oh, sure.
All right, let's take a 10-minute break. We'll be at recess.
Say to you is to emphasize some factors that hope that you take into account as you determine the proper level of discipline based upon the violations that you found. And of course, we respect the decision of the panel, thoroughly agree with it, but it is what it is, and we respect it, and we respect your close attention. At this stage, often what happens is by prior cases that are kind of analogous. Every case is different. This case is unique. I don't have precedent to say to you that, well, look at this situation, this is like this, like that. Never seen anything like this. What I would emphasize to you are two things. One is the testimony you just heard. Hope that you would find pretty compelling from Ms. Pedranza regarding Mr. Megaro's character and reputation and all of the good that he has done to clients and his high standing in ability and devotion to the profession. Mr. Cooper, his doggedness, diligence, in following through not only with Mr. Cooper, others that you've heard, this is a cumulative sort of thing, not just what you hear on Facebook. You've heard a lot of things. One, about Mr. Anderson, what he has done, but particularly say with Mr. Cooper, stuck with him for years, made a promise, he followed through on that promise. Got his life back. What did Mr. Megaro get? One, money, the satisfaction, helping another human being. There's hard work. Life. I would also point out, not necessarily a factor in you typically think. Caro, family man, he has children, obligations. We all. But in particular, what's important here, and it's set forth in the rule in a sort of a dry way. And I think this relates to the factor that can be taken into account of a couple of factors. I would say delay in the proceedings through no fault. After all, this original grievance came in about 4 years ago, 2017. And came public due to the actions of other folks, not even before moral procedure, that it would become public when referred to the DAC, so that the court of public opinion borrowed pride depicted in the press before he even had a chance to heard that and not found everything that was alleged. But he's gone through, I would just characterize it as 4 years of professional hell. Both of them. Always tough on the defendant, but there's special circumstances here. Pay public attention and the frenzy, indeed, pointed out before, articles in the big are saved on these allegations, assuming that they're all true, and all of them are, and there's always degrees. What I would call it, ask you to consider what it really is. This last 4 years, that to a great extent, the de facto active suspension. Affected his firm and his family financially. And public matter, obviously it's something that's, you know, burden to partners, employees, their say, clients. So in effect, he's all, as he say, already punished. I'm saying it, but I think in terms of the level of discipline that we actually impose, you should take that. That's taken in looking at these factors under the rule. I would say that comes under the category of imposition of other penalties. Not formal penalties, but penalties trial in the press, having I would say a vendetta of these other attorneys. But they're entitled to have their opinion. They up until the point the actual complaint was filed, some after the grievance was filed, Yeah, you're entitled to your opinion, but you should have kept your opinion. Not talk about yet another grievance that even State Bar had nothing to say about. Me, and it's just a gross thing. So you can probably anticipate, what am I asking? What I'm asking is that you consider fashioning discipline does not practicing law. Tell you what the options are. Also, I need to tell you what I would after Mr. Megaro like for you to do. I'm not going to do that, but you already know. How do you measure professional life? How do you measure life outside of the profession in this sort of situation, which, in my mind, is simply unprecedented already? Client has suffered emotionally, financially. But how much is appropriate? And I would also say, always back up here. What are we here for in the disciplinary process? Not to punish. That's the hope. And anticipate, I'm so far to argue, but I would say, protect the public from this. And I wouldn't say that you have to do anything, but whatever you do, it is not necessary to take away
Thank you, Mr. Williamson. Will it be argument by the State Bar?
Yes, sir. Title 27 of the North Carolina Administrative Code, Chapter 1B, 116F, provides that when considering suspension or disbarment, the panel shall consider all the factors listed therein. May I hand up a list of those factors along with 4 prior DHC cases that I will briefly reference during my closing?
All right, sir.
Thank you. I'll provide a copy to the defendant as well. I'd like to start by going over that chart, the factor chart that is the first of the selection I handed you up there. First section, suspension or disbarment is appropriate where there is evidence that the defendant's actions resulted in significant harm or potential significant harm to the clients, the public, the administration of justice, or the legal profession. And lesser discipline is insufficient to adequately protect the public. The following factors shall be considered in imposing suspension or disbarment. First factor that State Bar submits is present in this case is factor B. Intent of the defendant to commit acts for the harm or potential harm is foreseeable. The defendant, of course, did not accidentally have clients with diminished capacity execute a contract with him. He did it knowingly. He did not accidentally make arguments directly contrary to his client's interests. He did that knowingly, intentionally. Factor B, a finding of factor B is consistent with the findings this panel has already made in phase 1. Factor C, circumstances reflecting the defendant's lack of honesty, trustworthiness, or integrity. By my count, this panel has already found 5 findings of dishonesty in which the defendant engaged. This factor, factor C, is obviously present. Factor D, elevation of the defendant's own interests above that of the client. Factor is not only clearly present here, it is one of the primary characteristics of this case. The defendant elevated his greed above the needs of his client. He put his needs before his clients. He made arguments for his own benefit that were directly against the interests of his clients. So factor D is present. Factor E, negative impact of the defendant's actions on the clients or the public's perception of the profession. As we've seen from the countless news articles on this case, the public's perception of attorneys as a result of the defendant's actions is unsurprisingly and decidedly negative. Factor E is present. Factor F, negative impact of the defendant's actions on the administration of justice. Entire hearings had to be held to get to the bottom of the defendant's predatory treatment of Henry and Leon. The finding of factor F would also be consistent with this panel's findings of issues 8 and 11. Factor G, impairment of the client's ability to achieve the goals of the representation. Henry and Leon would have been so much better off if defendant had never stepped into their lives. Their goal was obviously to receive the entirety of their Industrial Commission Award, a trajectory they were very clearly on with Ken Rose and Vernetta Alston. Moreover, the defendant's arguments in the civil suit that were clearly against Henry's interests obviously undermined his still ongoing civil claims. Factor G is present. Factor I, acts of dishonesty, misrepresentation, deceit, or fabrication. Once again, multiple findings of dishonest conduct have already been made in this matter, so factor I is obviously present. In the second section, where we have the disbarment factors, where disbarment shall be considered where the defendant is found to have engaged in, State Bar submits factor A is obviously present, acts of dishonesty, misrepresentation, deceit, or fabrication. Once again, multiple findings of dishonest conduct have already been made in this matter. This factor is obviously present. Factor B, impulsive acts of dishonesty. I count 5 different counts of dishonest conduct, 1 to a third party, 2 to his own clients, and 2 to the courts. You've even seen multiple transcripts, and even in this matter, the defendant makes statements for which he was later impeached that were clearly dishonest. The defendant has a tenuous grasp of honesty. The truth is no barrier. He impulsively declares falsehoods without regard to the truth. Factor B is present. In the third section, sort of catch-all, in all cases, any or all of the following factors shall be considered in imposing the appropriate discipline. And this is on the back side of the chart I handed out. A, prior disciplinary offenses in the state or any other jurisdiction or absence thereof. We submitted in phase 1 the prior reprimand with our exhibits that the defendant has received. So factor A is present. Factor C, dishonest or selfish motive or the absence thereof. Once again, defendant's selfishness is one of the primary characteristics of this case. He put his desire for money above the needs of his clients. Factor C is present. E, indifference to making restitution. The defendant's retainer agreement, under which he collected a $500,000 excessive fee, was invalidated by a court of law in October of 2017. In the nearly 4 years since then, 3.5, he hasn't returned a penny of that money to Henry or Leon, despite having no other justification for having that money. Factor G, multiple offenses. Obviously, there's more than one rule violation in this matter and far more than just a single act of misconduct. Factor G is present. We briefly discussed factor L that the defendant mentioned in his closing, the delay in the proceedings due to no fault of the defendant. I will simply note Two facts that are evident from the record in this case, the procedural record in this case. The defendant was 100 days late responding to the amended complaint and took, I believe, if memory serves, over 8 months to respond to a motion in limine that was filed in this case. Obviously going to cause a delay, and that's certainly the defendant's fault. We'd submit factor L is not present. Factor O, refusal to acknowledge the wrongful nature of his conduct. Defendant stated at his deposition that he does not believe he did anything wrong. There's nothing he would do differently, except maybe change the language of his contract. And although he had the chance here today to take the stand during phase 2 and apologize, and it'd say, you know what, I did do something wrong. He didn't do that. He chose not to take the stand. He chose not to acknowledge the wrongfulness of his actions. He chose not to show any remorse at all. In fact, the defendant calls it fake news. The defendant claims he's already been punished, that he suffered a gross unfairness, that he suffered financially. I think he's actually describing Henry and Leon. They're the ones who have suffered financially. They're the ones who have suffered a gross unfairness. They're the ones who've been punished. And who's the cause of that? The defendant, Patrick Megaro. Factor O is present, refusal to acknowledge the wrongful nature of his conduct. And R, my goodness, R, vulnerability of the victims. This is really what sets this case apart from any other out there. You couldn't have a more vulnerable victim than in this case. The Talford case indicates that suspension or disbarment is appropriate where there is evidence that the defendant's actions resulted in, quote, significant harm or potential significant harm to the clients, the public, the administration of justice, or the legal profession, and lesser discipline is insufficient to adequately protect the public. I do have a copy of the Talford case if anyone wants one. I think it's one that the DHC is abundantly familiar with. So it's not in your materials, but I'd be happy to hand it up if you'd like it. So again, those factors are significant harm or potential significant harm to clients, public, administration of justice, or the legal profession. We only need one of those, but here we have 3. Harm to the clients. First and foremost, there's obvious harm of yet another betrayal by the justice system. These men were betrayed by our judicial system in 1983, and then an officer of the court betrayed them yet again in 2015. Second, Henry and Leon lost $500,000 because of the defendant's excessive fee. You heard testimony from Ken Rose, Renetta Alston, and Raymond Tarleton about how much they have been harmed by the defendant's actions. Third, Henry and Leon also have loan liabilities because of the defendant helping them get loans at exorbitant rates and under contracts that are clearly not enforceable because of their lack of capacity, including one against Leon's recovery that didn't go to him. There is clear, cogent, and convincing evidence of significant harm to the clients in this case. Harm to the public and the profession. Proper management of entrusted funds is a cornerstone of the public's trust in the legal profession. That did not occur here. Dishonesty to clients and the courts is one of the most serious offenses an attorney can commit, betraying the client's trust in the attorney and the public's trust in our profession. As lawyers, we are officers of the court. The entire system relies on lawyers being honest, not just with their clients, but with the courts. And here we have at least 2 instances where the defendant was dishonest toward courts. When the public reads an article like the ones we've seen, wherein they see that an attorney took an excessive fee from a mentally deficient client and told multiple lies, what can they think of our profession? It confirms the worst and saddest jokes about lawyers. This conduct. Clearly, this harms the public and the profession and the way the profession is viewed in North Carolina. Thus, the defendant's conduct obviously caused significant harm to the public and the profession as well. Discipline less than disbarment is insufficient to protect the public. It has been said that the measure of a civilization is how it treats its weakest members. Surely the measure of our profession is how we treat the weakest members of our society. How has the defendant treated some of those weakest members? As you've already found, took advantage of them, financially exploited them, he manipulated them. Those who are willing to victimize the vulnerable pose the greatest threat to our society. Defendant has refused to acknowledge the wrongful nature of his conduct or show any remorse. He has stated consistently that he did nothing wrong, that this is fake news, that the State Bar is overreaching by holding him to the standards of the profession. When attorneys refuse to acknowledge the wrongful nature of their conduct, there is no reason to expect that they won't engage in that misconduct again. And that's not surprising. Past behavior is the best predictor of future behavior, particularly when there is no remorse and no repentance, as is the case here. Because at present, there is every indicator that the defendant will continue to behave as he has in the past, the protection of the public requires that defendant show fundamental change before he be permitted to practice law again. And the only form of discipline that requires a showing of reformed character is disbarment. Defendant is a danger to the public. If he is permitted to continue to practice law, the public will be harmed. I'd like to briefly mention the DHC cases that I handed up to you all, and I do mean briefly. Predictably, when attorneys take advantage of vulnerable clients, the DHC does not respond leniently. This is not surprising. Attorneys, as I mentioned, are supposed to be trustworthy, to look out for their clients' interests above their own. That's what it means to be an attorney. Attorneys are advocates for their clients, not for themselves. Erica Erickson, which is 18 DHC 46. Ms. Erickson was disbarred because she assisted third parties in deceiving and exploiting several elderly individuals who were, according to this order that I handed up, particularly vulnerable to exploitation. There's nothing in this order that indicates they were mentally deficient, but it does indicate that they were particularly vulnerable, which is obviously a key characteristic in this case. Robert Leonard, which is 04 DHC 38, misappropriated money from a personal injury settlement and took fees to do post-conviction work that he did not do. And you'll note in the order that he was disbarred and that he must prove he made restitution to the harmed clients before he could be reinstated. State Bar would also request that the defendant not be permitted to practice law in this state again until he has made restitution to these clients from whom he took an excessive fee. Note here, even in a disbarment, you can do that, as the DHC did with Mr. Leonard. The Wolfenden case, 9 DHC 9, Elizabeth Wolfenden was disbarred for manipulating vulnerable domestic clients. Notably, there's no indication in the order that the clients were mentally retarded or had mental deficiencies, but nonetheless, she was disbarred. Finally, the last one, a very short one, Samuel Thomas. In this case, Mr. Thomas converted to his own use $500, not $500,000, just $500. No excessive fee, no mentally challenged client, no dishonesty to anyone, clients or the courts. No arguments against his client's interests, no elevation of his own interests above his clients other than the conversion of that $500. Just misappropriation of $500. He was disbarred. The common theme throughout the cases that I presented you is the vulnerability of the clients. You also note that in all four of those, the defendants were taxed with the costs of the DHC proceeding and the prosecution of the matter, something we are respectfully requesting this panel enter against the defendant as well in this case. In summation, the defendant did exactly what lawyers are expected not to do. He didn't act to serve his clients, he acted to serve himself. He conned mentally deficient clients he knew were mentally deficient, to kicking out their pro bono attorneys and hiring him for $500,000 that was guaranteed. He lied to a court multiple times. He mismanaged trust funds. He made arguments directly against his client's interests. He told outright falsehoods. In short, he behaved as no attorney ever should. Clients entrust lawyers with their livelihoods, their most important struggles, even their lives sometimes. As such, trustworthiness is the first and most fundamental characteristic a lawyer must possess. Through his multiple dishonest acts, revealing a willingness to deceive for his own profit, the defendant has demonstrated that he lacks the most fundamental characteristic required of all lawyers: honesty. Without a character of honesty and trustworthiness, he cannot be a member of our profession. As you've seen, the defendant's actions here have not gone unnoticed. An attorney preying upon mentally deficient clients who spent 31 years in jail for a crime they didn't commit has unsurprisingly drawn the attention of more than just the local media. Therefore, regardless of how this panel rules, a message will be sent today to the lawyers and citizens in North Carolina and in other states as well. One possible message is that even if a lawyer financially exploits mentally disabled clients and lies to them and lies to a court and makes arguments directly against his client's interest to protect his own fee and then doesn't apologize for it or even remotely acknowledge that what he did was wrong, he can still call himself a lawyer. He can still enter into contracts with clients and handle their money one day. He can serve as a fiduciary. He can still hold out to the public as a member of our profession and an officer of the court. That's one message we could send. Another message, the one we respectfully submit should be sent, is that if you lie, you financially exploit and take advantage of mentally disabled clients, you don't get to be a lawyer anymore, ever. The standards of the profession are higher than that. Lawyers are better than that. Respectfully, we submit the only way to protect the public and send the proper message is by disbarring the defendant. That will ensure the families and citizens of North Carolina are protected from this misconduct in two ways. Number one, we'll keep the defendant from harming anyone else. And number two, it will send a message to the other attorneys in this state that this behavior is unacceptable and engaging in it will lead to your disbarment. When someone calls himself an attorney, the public should be able to conclude that he isn't going to take advantage of them or financially exploit them. Lawyers, after all, are permitted to hold clients' money. Unscrupulous, predatory, manipulative. These words should never describe a lawyer. They describe the defendant. For these reasons, the State Bar respectfully requests that this panel disbar the defendant in order to protect the public. Unless there are any questions, I'll have a seat.
Mr. Walthall, if the panel were to consider restitution in some way, is it the State Bar's position that Mr. Megaro provided no valuable services to Mr. McCollum and Mr. Brown in terms of acquiring the pardon from the governor?
So I would look at it like this. What value did he add above who he replaced? The value above replacement. And he had Ken Rose and Vernetta Alston, who were actively and appropriately advocating on their behalf. He replaced them. I'm not comfortable saying he provided no valuable service, but did he provide service well above what he replaced? We would say no.
Well, so that goes to the issue of restitution, right? So without some determination as to what value of services those were, even if the panel were to consider restitution, how would that be determined?
I would refer the panel back to how we pled the excessive fee allegation, which just concerns the Industrial Commission matter. Before the Industrial Commission, he charged $500,000, just that matter. We do not see that linked with the pardon. And so we would submit that restitution would be in the amount that he charged for the Industrial Commission matter.
But you do concede that he represented the clients before the governor.
Yes, sir.
He prepared some documents, at least in terms of the petition, the final petition that was prepared, he prepared. That he prepared the witnesses to meet with the governor.
Yes, sir.
And so is it the state bar's position that that would have no value?
I'm not comfortable saying it has no value.
All right. Thank you very much. Those are my questions, Mr. Morris. Mr. Bennett, listen to the arguments of counsel, and we have considered both the aggravating factors and mitigating factors in regards to this matter. Wherefore, the panel makes the following ruling. The license of Patrick Megaro suspended for a period of 5 years, may reapply upon after 3 years with the following terms and conditions. Number one, that he pay the cost of this action. Number two, that he pay a restitution in the amount of $250,000 with $125,000 going to the guarded litem for each of Mr. McCollum and Mr. Brown. Number three, that prior to being readmitted into practice, that he complete 10 hours of continuing legal education. Number four, rather, that upon application to reinstate his license, that Mr. Megaro be supervised by an attorney that is approved by the state bar, and that supervision will take place for at least 2 years. That's the ruling of the panel. Mr. Walthall, will you draft a proposed order to that effect?
I or Mr. Murphy will.
All right, thank you. Or Mr. Murphy, I didn't mean to leave you out there in that task for that. And then circulate that to Mr. Williamson prior to submitting it to us.
Yes, sir. And may we inquire as to the factors to find?
Yes. No, I'm not sure that I wrote them down at this moment. Give me just a moment. I should be able to do that. I think I've got them. Actually, Richard, I might want you to do that after all. Do you mind go grabbing them? I should have brought them with me. You got them? Have you got them marked off? Give me just a minute, Mr. Walthall.
Yes, sir.
Okay, Mr. Walth, I'll apologize for not having that already prepared.
That's quite all right.
Using your sheet, Mr. Walthall, the factors considered by the panel in their deliberations include B, the intent of the defendant to commit acts where harm or potential harm is foreseeable. C, circumstances reflecting the defendant's lack of honesty, trustworthiness, or integrity. D, elevation of the defendant's own interest above that of the client. E, negative impact of defendant's actions on clients or public's perception of the profession. F, negative impact of the defendant's actions on the administration of justice. I, acts of dishonesty, misrepresentation, deceit, or fabrication. And under the, although it was considered and we did not issue the disbarment, we did A, acts of dishonesty, misrepresentation, deceit, or fabrication. Additionally, under it is, you're right, it's duplicated. I don't think you,
That it is often listed in both places.
Okay.
Yes, sir. It is a disbarment factor.
continuing on to the back page of the sheet that you gave us, the prior disciplinary offenses. That was A, C, dishonest or selfish motive or absence thereof. That's also somewhat overlaps with the other, I believe. Indifference to making restitution. G, multiple offenses. O, refusal to acknowledge wrongful nature of conduct. R, vulnerability of the victim or victims. We also took into consideration in 0.116, full and free disclosure to the hearing panel or cooperative attitude toward the proceedings. Q, character or reputation. And U, we considered imposition of other penalties or sanctions. Is that what you need, Mr.
Yes,
Walker?
sir. Thank you very much.
Gentlemen, yes, sir, Mr. Murphy.
With the cost, I just wanted to clarify that you could do both the deposition costs and
Is in there, there's a statutory identification of those costs, I believe.
I'm sorry for sitting there.
Okay.
As I understand it, and Mr. Murphy has tried far more of these than I have, but as I understand it, broadly a category of costs, including not only the cost of the actual DHC proceeding, which is a daily fee, but then also the cost of prosecuting the action. If I did not communicate that clearly before, that is what I.
Well, my understanding, at least in civil matters, and it may run differently, and here, and you correct me if I'm wrong, but there's a statute specifically on the costs that are allowed in these proceedings. I presume it's the same for the DHC hearings as it would be for. Just show it to Mr. Williamson, and if there's some.
It's my understanding.
That's what my understanding as well.
Actual cost,
That's my understanding as well.
And that is what is ordered here?
Yes.
Yes, sir.
Show that
Thank
to
you.
Mr. Williamson in advance, and then if you guys cannot, if you can't come to a reasonable understanding of what those are, then
Yes, sir.
I'll resolve the issue.
Yes, sir. Thank you.
All right.
I would say, it's my understanding, generally, after the order is entered,
And there's a time period by which they will be paid.
yeah, right.
It's fine.
But both of you know, sounds like you know more about it than I know, so I'm just yielding to the attorneys in this case, so.
The effective date of the order, or statute, usually it's.
Yeah, I think that's fine.
Thank you.
Gentlemen, thank you very much. Best of luck to you, Mr. Megaro, and the others, and the hearing is now concluded.
May I approach?
Yes.